What's up, guys? Welcome to Kitchen Court Cases, where we watch court in my kitchen. Hold on. Maybe I got both. I think I got them both. It's awesome. Great news. I don't know if you can see me. I am on your screen right now. I am fitting right in with the people in Judge Manning's court. What I've decided to do today, folks, if you're new here, welcome. We do lots of different fun things, one of which is playing word games. And today is a word game day. So we are going to be playing our Wordle game. That works. Well, how we're going to figure it out, basically, it's going to pop up right over here. There it is. And we are going to be playing the chat words game. It's Wordle, 5-letter words. We work together as a team so that we can do it together. It's it's meant to be fun. I haven't gotten to watch Judge Manning in a long time. I'm not muted. Am I muted? That'd be funny. Arbitrary hubris, thank you. Oh, so many times I've done that. I won't tell you. Okay, so mints and tatties. Oh, I understand, I understand. Okay. So how the game works is we guess in the chat. I think what we're going to do is assign a team leader. So if you're new here, you need to clock in for your shift. You clock in for your shift by hitting the like or the dislike button, and we keep track right down here. You can see there's 12 of you that have done this probably so far, and yet there are 25 people in the room. So, oh, 13. Okay, yeah. I'm speaking to the 15. Okay, there's still 10 of you. But I put this here so that we can help you realize. Okay, 17. Excellent. We're working. That's getting good. Um, let's see here. So, seriously, I am here. I'm in this little booth. You can't barely see me, but I am here. What we're going to get doing, we're going to play Judge Manning because, like I said, I've been so busy doing other court stuff that I haven't actually gotten a chance to see Judge Manning in her glory as much as I would like. And so that's what I've decided that we will watch tonight while we do our word game. I think what we're going to do is, woo, Mark Demaline.
Oh, yeah.
Thank you. That's awesome. Um, so I'm gonna get us started with a test version of it so that I can show you guys. We did recently decide on. I'm trying to think here. We did the alphabet A B C D E, and then we'll see how that pops up. It sometimes, well, everybody has their own different way of playing Wordle. Let's just put it that way. Anyways, so perfect. We're at 20 likes, you guys. I love it. I love it. I love it. Okay, here we go. We're gonna that apparently didn't work, so I'm gonna have to look at what the command is here first. Charles as vagina. I don't know about that one, Charles. That might be the case. It might not. I think I need to be able to see what the timing is. That's the issue. Here we go. Okay. What happened to Manning TPO Friday hearings? I think what happened to those hearings is the same thing that happens to a lot of things we love. They got too big for their own good and they had to um, stop broadcasting them. I don't know that officially, but I think so. Um, Karin says, can we establish that real words must be used as guesses? I would likely agree, Karin, except that I personally see, look, okay, so my first guess, first of all, that took a long time. Second of all, that took a really long time. But second of all, I theorize that if we utilize my method of guessing the letters in order, we can knock out like 15 letters in 3 guesses and then very, very likely guess the word. That's my theory. Um, there's no E in this word, guys. So although I like crater, I like cater, I like crate, no E. So why don't we get Judge Man going? Everybody, cameras on, stay on mute. Cameras on, stay on mute. And crack. I love you guys so much. So what I think my theory is the next guess would be um let me see here. It would be FGHJHIJ. Oh, I have to put in try first. um George, I was just reading that it's illegal. Nightmare. Yeah, I understand. I mean, honestly, the reality is, I think you guys know this about me, but I have some pretty standard rules that I use for myself in order to keep what I do fine for me. One of those things, okay, see, so I fucked that up. EFGHIJ. But uh I don't ever title a video with a defendant's name. I use judges' names, but I never, for a reason, use use a defendant's name. I personally don't want to be the reason that somebody can search them on YouTube and go through to find them. And so that's my own methodology of making sure that that happens. The other thing is that, again, like we're court watchers, and I think for people watching court, it's like different. We sort of understand them, but it's not really for the same for like people that are, looking for somebody that's watching, like somebody that they want to see. That's a totally different genre of viewer. So while I understand that TPOs might be difficult to handle sensitively, I personally still air them when I can catch them, but I have a few ways that I prevent that from getting worse. Anyways, so my theory is not working great, but let's just continue on one time with this one. So HIJK, so it'll be KLMNO. And here's the other thing, guys. These are like sobriety tests, right? Almost. You guys think crack is good? Georgia, we've talked about this. Crack is a bad drug. I'm just kidding. Um, oh, somebody else put a good word, another guess in there, but it doesn't have T, no S, no R, no W, no N. My goodness. Agree, Chris. Like if people put in like, yeah, exactly. We're not necessarily the only people that have it. However, actually this brings me to one other point before we get started. Um, People often complain about me interrupting my lives. Just listen to that for a second. Me interrupting my lives. Okay. They think I'm interrupting them. I personally show TPOs in live format so that I can interrupt and interject when I feel needed. So, for example, that one we had last week with that dude with the BMW and all that kind of stuff. Um, yeah, I wasn't gonna post that with no commentary and just let people come up with, their own conclusions on that. If they want to do that, go ahead and find that video yourself, record it and do that. But if you don't have the ability or you haven't done that, then you might be stuck watching it with my commentary over it. And that's just the way that's going to be. And I personally think that is one of the ways that I feel okay putting these cases up. So I did go back actually and listen to a few of my rants. They were definitely a little crazy, but and I don't really care. I just like to explain, like, if you'll notice, my videos that I've been posting lately are very much different than my lives. I have an intro, I might interject a little bit, and then there's an outro, but the content is different. These are not difficult cases that need to be explained. Whereas, for example, that last one was. And I remember thinking, like, again, because I don't use their name, so people are not going to be drawn back to it based upon their name. But just in case, let's say that woman ever does happen upon that case, I really would like her to hear me bitching about him. You know what I mean? Like, that's what I would like. I don't think it's too much to ask. Anyways, okay, let us go ahead. Let's get started. I don't think it's cause because there's no S. I think it could be clamp. It could be clamp. Oh, we will do more Judge Kim, absolutely. But I literally miss Judge Manning, haven't listened to her enough lately. And so this is a little bit selfish of me, but I want to do this. So let's see here. Okay. What was I going to say? Oh, right. No, I can't remember now.
gun, and it was not within his arm's reach. Judge, he does have a good address. It is in Atlanta, 30315, and he has ties to community, including his grandparents. I believe the address would be in Fulton County, and Your Honor, he is on a no bond status currently. We would ask the court to consider $5,000 for count one and $1,000 for the misdemeanor obstruction in this case. Judge, this all occurred because Ms. Crittenden, who's listed in the warrant, was unhappy with my client, and we need further information, but my understanding is the gun was found inside the home, so not in my client's arm's reach. Nothing further.
All right, go ahead, Mr. Marquez.
Thank you, Judge. The state is going to ask the court, just based on the fact that Mr. Love's history, he does have a high probability to reoffend, and that he has a clear history of not appearing for trial when called, with several TAs and parole violations. So we believe that he is a danger to the community. So the state would ask for, at a minimum, if the court does set a bond of $50,000 on the possession by firearm by a convicted felon, and $1,000 on the misdemeanor.
All right. No drugs unless prescribed, no alcohol, no weapons. With your record, we're going to put an ankle monitor with a 24-hour curfew. Court, lawyer, medical, employment, as long as you supply the name of your employer, proof of employment, schedule, exact location you're going to be working. You also can do for basic life necessities. No further contact with Nicola, Nicola Crittenden, Crittendon. Do 10,000 count 1, 1,000 count 2. Best of luck to you, sir. Thank you, courtroom 2.
Woo! It was Clamp, baby. Good job.
All right, Gary Bell. All right, let's see. There she is. All right, 22 CP 213876. This is position 9. Gary Bell.
Good evening, Judge Aya Bader for Mr. Bell. Mr. Bell's been in custody for about 211 days now.
Need to kind of like just put everything on the record, if that's okay, real quick. Sorry. All right, it's 22 CP 213876. Gary Bell. Theft by receiving stolen property, possession of a firearm or knife during the commission of or attempt to commit certain felonies, possession of a firearm by a convicted felon, driving a license suspended or revoked, possession of drug-related objects. And it was bond set on May the 18th. It's been standby. Odyssey was going a little slow for me today. May
Don't worry,
18th
Judge.
bond was set at $7,500 good bond.
17 cycles, 2018 forgery conviction, 2011 habitual violator convictions, 5 probation violation, and nothing further.
All right, go ahead, Ms. Badar.
Yes, Judge. He's been in custody for 211 days now. Today we're going to ask for a UJR to his hold. He does have a hold in Lowndes County for 3 traffic offenses. The hold is causing a lot of barriers for him, most significantly in getting into a program for substance abuse, as he has requested. Just for some more Ayala factors, he's been a Georgia resident his whole life. He has a good address with his brother, Marvin Collins, who I've spoken to personally in Henry County at 233 Happy Trail, Locust Grove, Georgia, 30248. I do believe that address is different than that on Odyssey. As you heard, he doesn't have a long history. It is nonviolent. So we're asking for him to go to his hold so that when he returns, we can resubmit him for substance abuse treatment. Thank you.
All right, go ahead, Mr. Marquez.
Thank you, Judge. The state believes in this case, since a bond has been set of $7,500, a good bond, and that was set recently, the fact that he is a repeat offender, he is at risk to reoffend, and he poses a substantial danger to the community. We are going to ask that the court leave the bond as is.
All right. No drugs unless prescribed, no alcohol, no weapons. You're going to have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, employment, basic life necessities. Employment, as long as you supply the name of your employer, proof of employment, schedule, the exact location you'll be working. You'll have 48 hours to have that ankle monitor placed on your ankle once you're released from your hold. No driving unless you had valid license, registration, and insurance. Stay out of Fulton County except for court and to see your lawyer. 1 second, make sure I've got everything here.
Did you hear that, folks? Stay out of Fulton County. I love that, Brian and Kimmy. That is so great. So RSTWN, no guesses. Seriously, I love hearing Judge Manning say pretrial and stay out of Fulton County. It warms my heart. Warms my heart.
And it, once again, it'll be paid for by the county. So 1,000 count 1, 2,000 count 2, 2,000 count 3, 200 count 4, and UJR through the jail for count 5. So that's 1,000, 2,000, 2,000, 100. 200, and then UJR jail. Best of luck to you, sir.
Thank you, Judge. That concludes my business. May I be excused, please?
Yes, ma'am. You can leave the booth, Mr. Bell. Philip Gordon. All right. Ms. Pinto, this is 22 CP 213678, 218 days without indictment. As of March 3rd, there is a $7,500 good bond on aggravated assault.
51 cycles, 3 FTAs, 5 probation violations, possession of cocaine convictions, 2016, 2009, robbery convictions, 2009, 2008, and possession of controlled substance convictions, 2006.
Before you start, Ms. Pinto, so did everybody see the message? Michael Caine, position 8, has refused to come to court.
Sir, sir, do you know the opportunity in front of you to see Judge Manning? People here in this chat room want to see Judge Manning, and you're refusing? That's ridiculous. Also, I've just decided I'm going to make beans because I want them. So, I'm going to make them. Burger sliders for dinner from That Is the Way I See It. Lemon Oreos? They have those? That's weird. Not in Canada. What else did anybody else have for dinner? I literally am deciding I'm gonna make some beans. This is my Popeyes bean copycat recipe. Okay. I will make them in the Instant Pot, and I have coffee to drink. And I was watching the dog today, and there's a dog hair. Fucking shit. Okay, let's keep going. Just had some Doritos from Sashina. Tequila Sunrise for Trish. I love it. Mixed rice and veg, beans on toast.
Not sure off the top of my head who represents Mr. Cho. So your clients refused to come to court. Just
Can we reset him and I'll speak to him?
all right.
Okay, I'll reset it.
Thank you,
Okay.
Ms. Robinson. Thank you, Judge.
Okay.
That concludes my business, Your Honor.
Yes, sir. Thank you. All right, go ahead, Ms. Pinto. I apologize.
Thank you, Judge. Mr. Gordon has been incarcerated 218 days. He has been, of course, deemed eligible for a bond. We're simply asking for a reduction based on his financial circumstances. If released on bond, he would reside on Magnolia Street in Atlanta. I think that is the address on file. But that's where he would live if released. He's not a flight risk judge. He does have ties to the community. He's 35 years old. He's lived in Atlanta his entire life. His entire family is here in the Atlanta area. And he's not a risk of intimidating any witnesses or alleged victims. This alleged victim is not someone that he knows personally or would have any means or reason to contact. So we are asking for a reduction based on the fact that Mr. Gordon is indigent and, of course, presumed innocent. He has very little by means of finances. So we would ask for a reduction by half, Judge.
Okay. And just so you know, I've already put anything over 200 days in my email to Ms. Willis.
Thank you, Judge.
Go ahead, Mr. Marquez.
Thank you, Judge. At this point, the state believes that this is an aggravated assault. A bond's already been set at $7,500, which is substantially low on this type of charge. The defendant does have quite a few FTAs, so we believe that he is at risk to reoffend and risk of flight, potentially not even showing up for court. Despite the fact that he doesn't know the victim personally, he could become a danger to the community simply because of the nature of the charge. That's the state's position, Judge.
All right. No drugs unless prescribed, no alcohol, no weapons, no further contact with Corey, Cory, Andrew, last name Martin, Martin. Stay away from 89 Centennial Olympic Park Drive, Northwest in Atlanta, Georgia. You're going to have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, employment. As long as you supply the name of your employer, proof of employment, schedule, and the exact location you're going to be working. Also, sir, you can leave for basic life necessities and stay away from Reverb Hotel, which REVERB, which should be that location. 218 days, no indictment. I give you a $5,000 good bond. Best of luck to you, sir.
Thank you, Judge.
You can leave the booth. All right, I got Devin Blaylock. All right, position 12, 22 CP 212715. Devin Blaylock, 254 days without indictment. There's a $98,500 good bond as of December the 27th, 2022. Possession of marijuana with intent to distribute. Possession of a controlled substance, Schedule 3, 4, or 5 with intent to distribute. Possession of cocaine with intent to distribute. Possession of MDMA with intent to distribute. VGCSA, possession of Schedule 1 or 2 with intent to distribute.
I'm pretty sure she means possession of MDMA. But hey, if there's a drug called MDNA, maybe I gotta try that one.
Possession of a knife or a firearm during the commission of or attempt to commit certain felonies. Possession of a firearm by a convicted felon. Violation of handicap parking. Misdemeanor obstruction. That's allegedly 61 grams of weed, 3 grams of Xanax, 4 grams of crack, 61 MDMA pills, and 12 grams of Adderall. All alleged, Mr. Cazzoli. Go ahead. I mean, free trial.
That is a party. I'm sorry. I love it. Pre-trial. And thank you, Orlando Chiquita. Donna, we love you so much. Remember, guys, to get right to the live part of the show if you want to play the word game. Daylight Disinfectant starting us off with a perfect guess.
Oh, yeah.
I really hope that the answer is penis. We will see. I love you guys so much. Seriously, that's quite a party. 61 grams of weed, 12 grams of something else. Quite a party.
Oh, well, 3 grams of Xanax, 4 grams of crack, 61 MDMA pills, and 12 grams of Adderall. All alleged, Mr. Cazzoli. Go ahead. I mean, free trial.
I'm showing 7 cycles, 4 out of Georgia, 3 out of Tennessee. Give me one moment to pull his GCSE up because no felony convictions were actually listed.
I know
Give
MDMA
me
is
1 second,
ecstasy.
please.
What I was saying, she said MDNA, and I thought that it was another one. I'm, yes, aware of MDMA.
It's loading.
You want to screenshot that, Georgia Beach?
Does the state show any felony convictions?
I'm looking, but I don't see any on GCIC so far.
Trying to pull it up and look at the warrant again.
I'm sorry, my Odyssey's going really slow, Judge. Don't know why.
Yeah. Mine too. Just spinning, loading.
Pretty much.
I don't see any felony convictions listed. I was also trying to pull up the possession of firearm by convicted felon warrant to see if that was one of the arrests out of Tennessee. But my Odyssey is also moving pretty slow.
Mine's going so slow too, Judge. I don't know.
Well, Mr. Cazzoli, you want to go ahead and make your argument, and we'll come back to the possession of firearm by convicted felon?
Sure, Your Honor.
Okay.
Thank you very much and good evening. Mr. Blaylock is 30 years old, Your Honor. As you already mentioned, he has now been in jail for 254 days. And it's my understanding that that is already included on your list, Your Honor. But we would just like to point out that his last hearing was in January, Your Honor. So that means that it's been almost the end of December. So that's over 6 months of uninterrupted time that Mr. Blaylock could have been indicted if the state was hoping to do so. Your Honor, he had a good job working at Discounts Meats as a delivery driver before his incarceration. Your Honor, he is a lifelong Georgia resident. He has a good address that's listed on his file. That's 1005 Baldwin Street, Southwest, Atlanta, Georgia, 30310. Your Honor, I will also point out that that he currently has a 98 over $98,000 bond. As if this was being charged as trafficking, Your Honor. But as you listed out the amounts, none of those rise to such a significant level. We are asking for significant downward departure there. We're asking for his bond to be reduced. Let's see, 1,000 on position 1, 2,000 on position 2, 4,000 on position 3, 20,000 on position 4, 5,000 on position 5, 5,000 on position 6, 5,000 on position 7, keep position 8 as UJR jail, make position 9 UJR jail as well.
So in the warrant, it says 5/10/2022 out of federal court, he was convicted of conspiring to distribute narcotics felony.
And I reran a GCFC. I see that with the U.S. Marshals. See, the supervision date did start 5/10/2022 for that offense. And he also had a 8/28/2013 for conspiracy crack cocaine, also with the DEA.
All right. Go ahead, Mr. Marquez.
Thank you, Judge. Well, in this case, considering Mr. Blaylock is a convicted felon and he is a repeat offender, we consider him a danger to the community and a flight risk and potentially also a propensity to reoffend. So we are going to ask the court to keep the bond as is. And I'm not sure, Judge, but I think some of these amounts, because I don't have all the amounts on the actual possessions, but may trigger Brasher's order. I'm just not sure.
All right, let's see. So it's 254 days without indictment. No drugs unless prescribed, no alcohol, no weapons. Stay away from 221 Cleveland Avenue Southwest. You're going to have an ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical, employment, as long as you supply place of employment, name of an employer, schedule, and the exact location you're going to be working. So I got 1,000 for count 1, 3,000 for count 2, 4,000 for count 3, 30,000 for count 4, 5,000 for count 5, 7,000 for count 6, 7,000 for count 7, UJR jail, and then 1,000 for count 9. 1,000, 3,000, 4,000, 30,000, 5,000, 7,000, 7,000, UJR jail, and 1. Best of luck to you, sir. And I did put it in there, and I highlighted all these in red today, too, if that helps. All right, let's see. Marquise Clark. Best of luck to you, sir. Marquise Clark. All right, we got Ms. Beck. Yep. All right, we got 23 CP 215433, 147 days without indictment, no bond as of January the 14th for aggravated assault. Free trial.
5 cycles. Out of those 5, only 2 were adult cycles, and he has no adult convictions. He did have some adjudicated guilty juvenile cases.
All right, go ahead, Ms. Beck.
Thank you, Your Honor. Mr. Clark is 18 years old. He celebrated his birthday while in jail. He's a lifelong resident of Georgia. We do have a good address. I do need to file a change of address, but it is here in Fulton County. His mom, his dad, grandma, aunties, siblings, they all live here in Georgia as well and are very supportive of him. He went through the 11th grade, but he's not sure if he'd be able to go back to the same school if and when he is released, but he will be going back to school. So we would be asking for an exception for school. We are asking for a bond not to exceed $20,000, Your Honor.
All right, go ahead, Mr. Marquez.
Thank you, Judge. In this case, Mr. Clark presents a danger to the community, we believe, and to the victim. In this case, he is a repeat offender. Granted, some of those were juvenile, but because of his age, I am concerned with the safety of the community and his propensity to reoffend. So the state would ask for a $50,000 bond in this case.
All right, so he's definitely not going to live in Columbus, Georgia.
Not that I'm aware of, Your Honor, no. I'm not trying to misrepresent, but my understanding was Atlanta.
Okay, all right. No drugs unless prescribed, no alcohol, no weapons. Stay away from 5651 Stonewall Tail Road in Atlanta, Georgia. No further contact with LaShawn, Lasean Johnson. You're gonna have an ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical, and education, as long as you can show proof of enrollment and that you're going, sir, and basic life necessities. That ankle monitor will be paid for by the county. $35,000 good bond. Best of luck to you, sir. Jamie
Vicky,
Quinn
there's
Andrews,
no
Mr. Andrews. Sorry if I destroyed your name there.
judgment.
All right,
Just
we
let me-
got position 13. It's 23 CP 21650.
Thank you. Vicky, you need to. It's like exclamation mark try space 5-letter guess. I don't. It's not working. It should work. I had to get the recipe for the beans. That's what I was running to get. But you guys, so far we're 2 for 2 with the word game. I just want to say that.
.03, no bond as of March the 8th, 2023. Jamie Quev Andrews, 105 days. Possession, manufacture, distribution, sale of marijuana. Possession of a firearm or knife during the commission of attempt to commit certain felonies. Possession of a firearm by a convicted felon. Possession and use of drug-related objects. Unlawful for a person employed by, associated with criminal street gang to conduct or participate in criminal street gang activity. Unlawful for a person employed by, associated with criminal street gang to conduct or participate in criminal street gang activity. Unlawful to commit an offense with the intent to obtain, earn, maintain membership, or increase status, position in a street gang. 48.5 grams of weed allegedly. Pre-trial.
22 cycles, appears to be on probation for aggravated assault, theft by receiving stolen property, unlawful for person employed or associated with criminal street gang to conduct or participate in criminal activity, robbery, possession of a firearm by convicted felon. That is from 2014. It was 15 years probation, 13 SC 117373. He has 2 burglary convictions, 2015, 2014, 2020 conviction for possession or transport of a firearm by a convicted felon or felony first offender. Another open case, 22 CP 213377, failure to use crosswalk, willful obstruction, reckless conduct, purchase, possession, or have a controlled substance in Schedule 1 or narcotic in Schedule 2, purchase, possession, manufacture, distribution, or sale of marijuana, and unlawful for a person employed or associated with criminal street gang to conduct or participate in criminal activity. 3
All right.
probation violations, 1 FTA.
Thank you. Go ahead, Ms. Beck.
Thank you, Your Honor. Mr. Andrews is 27 years old. I'm sorry, 29. I can't read my own handwriting. He is a lifelong resident of Georgia. He's lived here his entire life as well. His family has lived here forever. His mom, every single family member he has lives here in the state. We do have a good address. It is not the one that is on file. However, we will be filing a change of address. It is in Fulton County though. He has 2 children at this point, and he has not gotten to meet his newborn child yet. She was born while he's been incarcerated. He went through the 10th grade, but also went back and got his GED. Prior to his arrest, he was working for Hands On, doing election campaigning work, and he did that for 5 to 6 months. And he had also just gotten an interview with Amazon. He hadn't started yet prior to his arrest. We are asking for a bond not to exceed $10,000, Your Honor.
All right, what says the state?
Judge, criminal
Judge,
street
this is,
gangs
I'm sorry,
and-
this is
Oh, sorry.
ADO Com with the gang unit.
Oh,
Yes,
go ahead.
ma'am. Go ahead.
Sorry.
Ooh, gang unit. Is that better?
Your Honor, the state is objecting to bond. I would note that the defendant has an extensive criminal history. I would also note that the open case was for the same circumstances. It was a drug case and also participation in criminal gang activity. He was bonded out for that. He got bail for that. Well, he posted his bond December 4th for that case of 2022 and picked up this case February 4th of 2023. So he was basically out on bond for 2 months before he picked up this new case. And Your Honor, the state is also particularly concerned that he picked up basically similar charges, criminal street gang activity and drugs. The defendant is a danger to society. He's also on probation for various cases. He has various felonies on his record as well. And the defendant has clearly shown that if he's released, he will pick up a new case. The state is concerned for the community at large and the defendant's propensity to commit new crimes. So the state is objecting to any reduction of bond, and the state is asking that the defendant remain on no bond status.
Well, it's 105. So that'll.
I apologize, Your Honor. I have
That's
multiple
okay.
cases.
That's
I'm
okay.
asking that it not be reduced, Your Honor. I'm surprised it's at 105. I'd have asked for more, but the state is requesting.
Oh, no, he's been in jail 105 days. He's at no bond status.
He's
Okay.
legally entitled at this point.
Your Honor, the city is asking for for that case, for the gang counts, $75,000 each for the gang counts. For the drug counts, $20,000 for the possession of a firearm by a convicted felon, $20,000. I'm going to do my math, but it should be 75 plus 75 is 150, 1, 2, 3, 150, 300, 375. I think if my math is correct, it should be 475, but I can check.
No
that.
M.
No drug unless prescribed, no alcohol, no weapons. Stay away from 215 Forsyth Street Southwest. You'll have an ankle monitor. Oh, and also no replicas of weapons. No replicas of weapons, no social media. You have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, employment, as long as you supply the name of your employer, proof of employment schedule, and the exact location you're going to be working. No further contact with anybody who's a member of or any gang members, but especially sex, money, murder, YSL, Atlanta Blood Gang, YFN. And of course, you know what that means. I don't really want to say that, but any of those gangs or any other gang members, affiliates of gangs, wanting to be a gangs, trying to be a gang, thinking of being gang, any thing like that. 20,000 count 1, 20,000 count 2, 20,000 count 3, UJR through the jail for the drug related objects, and then 100,000 on each gang charge. So 20,000 on each drug case, UJR jail possession of drug related objects, and 100,000 per gang charge. That's what 360. Best of luck to you, sir.
Your Honor, I apologize. That concludes my matters with you. May I be excused?
Yes, ma'am. Have a good evening.
Thank
And we got
you.
Robert
Yeah.
Swindle. And then Miss Eustace, if you're still here and haven't gotten your verdict.
I am, Judge. Thank you.
All right. Ms. Bray, we got position 3, Robert Swindle, 23 CP 215494, 143 days of indictment. There's a $10,000 split bond with 10,000 on simple battery, no bond on robbery, 143 days. Pre-trial.
13 cycles. Open case for theft by shoplifting, 23 CP 218826. Open case for forgery of financial theft, theft by shoplifting and forgery, financial transaction card fraud, 21 CP 202720. And an open case for terroristic threats, robbery by force, driving hit and run, 21 CP 197278. 2 TAs, 1 misdemeanor probation violation, and nothing further.
All right, go ahead, Ms. Bray.
Hey, good afternoon, Your Honor. Mr. Swindle is 25 years old. He has a high school diploma from Maynard High School. He was attending a barber program prior to his arrest. He has lived here in Georgia all of his life, and his main support from his family, the family members are all here in Georgia. Just virtue of the fact that he does not have bond and it's over 90 days, he is entitled to bond on the charges that he no longer has bond on. I am going to point out to the court that 2 of the cases that are open do not belong to my office. He has a private attorney on those. And I am just asking Your Honor to set a bond on his behalf. And this is one of the cases that I inherited from
Mr. Houston.
Mr. Houston. Oh, and I need to provide a new address, and I'll go ahead and do change of address form tonight. But Mr. Houston spoke to someone with the first name Tedrick, Tedrick. I don't have a last name, but that person informed Mr. Houston that Mr. Swindle would be living at 2428 Stone Road, East Point, Georgia, 30344.
All right, go ahead, Mr. Marquez.
Thank you, Judge. In this case, because of Mr. Swindle's age, he has 3 open cases. for substantially similar circumstances. We consider him to be a danger to the community and a high propensity to reoffend. So we would ask the court to set a bond in the amount of $30,000 for the robbery and keep the simple battery at $10,000.
No
And of
drugs
course,
unless
I'm asking for substantially less than that, simply because he has been in for the amount of time that he's been in and nothing has happened.
All right, no drugs unless prescribed, no alcohol, no weapons, no further contact with Francisco Ramirez Sanchez, Sanchez. Stay away from 3097 Maple Drive. You're gonna have an ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical, employment, as long as you supply the name of your employer, proof of employment, schedule, exact location you're going to be working. Sir, are you going to be living at that East Point address? Thumbs up or thumbs down? Okay, so we'll remove that, stay out of Fulton County. That ankle monitor will be paid for by the county, and all these, Miss Hunter, they have 48 hours if there are any holds pop up. So 10,000 count one, 20,000 count two. Best of luck to you, sir. All right, Miss Eustace, you're it. Is that it for you, Miss Bray?
No, I believe I have two others on the calendar. I wanted to tell Your Honor that Robert Lyons needs to be removed from the calendar because when I checked this afternoon, he did in fact receive a UJR. And I guess when they were processing him out yesterday, up popped a violation of probation hold for a 2019 case. So the 2019 case is the only case that is holding Robert Lyons in.
So do we need to get that on here, I guess, right?
I guess.
Okay.
Judge, I think that's one of the ones you had removed.
Yeah, okay.
Oh, okay. I must not have heard that part. I may not have been on.
That's okay. All right, what about Stephen Osby? All right, you ready, Miss Eustace? Position 17.
Your Honor, I'm sorry to interrupt. Mr. Osby is represented by Ms. Rondon. That's the reset from Monday.
yeah.
I'm sorry, from Tuesday.
Okay. All right, Ms. Rondon, it's just one. I'll take her. Stephen Osby, 23 CP 216599. 101 days without indictment, no bond as of March the 1st, burglary in the first degree, theft by taking felony. Pre-trial.
Give me 1 second. This is the only one I don't have.
No problem. Take your time, ma'am. I'm making the beans. We're gonna add in this liquid smoke, the Cajun seasoning from the keg, and the
I'm
chicken
showing 16
stock.
cycles out of Georgia. 1 FTA 2018. He took a first offender in 2021 for willful obstruction and criminal damage to property in the first degree. He appears to still be on first offender probation for that case, 19 SC 173511. It was 3 years, 3 months probation. Another FTA from 2020. Probation violations, 2020, 2022. Another one in 2022. 2023 probation violation. He has 1 cycle out of North Carolina for assault with a deadly weapon in 2016. Looks like that case was dismissed. I believe he has another out-of-state history. It's loading.
Strap is in strap
And he
on, but it's
also has
coming
arrest
out.
out of Florida. 1 cycle out of Florida for domestic violence battery in 2015. He completed PTI for that case and nothing further.
All right, go ahead, Miss Rondon.
All right, Mr. Osby is 26 years old. He has been a resident of Atlanta and Georgia for the past 4 years. I will be submitting a change of address for him.
Judge, I'm sorry,
Or-
he's waving in 1 North booth too. I'm not sure if he can hear.
Sounds like he can't hear us, or it looks like he can't hear us.
Go to booth 3. Swap.
Once you put all your bean stuff
Okay,
in
go
the
ahead.
Instant Pot.
I will start from the top now that he can hear us.
Okay.
Mr. Osby is
Before you do, let me get the bean thing out, and then you can go on, ma'am. So you go ahead, you do the liquid smoke, you do the Cajun seasoning, you do the chicken stock, the dry beans, garlic, onions, and then it goes on. Oh, this is the hard part. Okay, so you got to make sure your seal is good. If you're really bougie, you have multiple seals for different types of things that you make. I'm not bougie, so I just make sure my seal is on. Lid on, put it to sealing, then you go manual, adjust, oh wait, manual, fuck. Okay, apparently you just do manual, then, okay, no, that's not how we do this. Wait, I've written it down. Cook in Instant Pot on high for 80 minutes for dry beans, 60 minutes for canned beans. I'll let this play. I'll figure it out.
26. He has been in Georgia for the last 4 years. I will be submitting a change of address for him, as his new address is in Conyers, Georgia, where he will be able to reside with his mom. He is a high school graduate, and prior to being arrested, he was working at Longhorn Steakhouse. And it is my understanding that he would be able to get that employment back once being released. Mr. Osby does have some MH issues that would be better served outside of confinement at Fulton County Jail. I would ask for bond to be set in Mr. Osby's case, not to exceed $20,000 total.
All right, what says the state?
Judge, in this case, Mr. Osby does have a few cycles. We are concerned with him reoffending and potentially fleeing the jurisdiction, since he sounds like he has some.
Were you worried about him going to the plaza? That was the win. Good job, guys. We're getting them all today. We're getting them all. If you're just joining us, we're playing word games. We're watching court. I'm cooking beans. This is how we do.
Cases from Florida. The state would ask for the 2 counts, a total of $20,000. No contact with the victim, and do not return to the property.
All right, no drugs, no alcohol, no weapons. Stay away from 725 McWilliams Drive Northeast. No further contact with Siobhan, Shevan, Howard, common spelling. Stay out of Fulton County unless you're here for court or to see your lawyer. You can have an ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical, employment. As long as you supply the name of your employer, proof of employment schedule, the exact location you're going to be working, and also basic life necessities. $10,000 per count, $20,000 good bond. Best of luck to you, sir. Thank you, Ms. Rondon.
Thank you. I believe I have one more case on the calendar, so I'll stick around.
Okay. All right, Miss Eustace. Marquise Gilmore. All right. Position 20, 23 CP 216605. 101 days without an indictment, no bond as of March the 3rd. Marijuana possession less than an ounce. Use of a firearm by a convicted felon during the commission of a crime and criminal trespass. Pre-trial.
10 cycles, appears to be on probation out of Clayton County for burglary, theft by receiving, stolen property, robbery, and false imprisonment and terroristic threats from February of 2020. That was the first offender that was revoked. It's 10 years probation. 2018 conviction for possession of cocaine with intent to distribute and possession of MDMA. Also appears to be on probation for 18 SC 159035. That is for possession of marijuana with intent to distribute. From 2019, 9 years probation. Open case 23 CP 213572 for willful obstruction of a law enforcement officer by use of threats or violence. 1 FTA, 2 probation violations.
Go ahead, Ms. Eustace.
Yes, Your Honor, and thank you for squeezing me in. I appreciate it. My client turned 28 years old while he was in custody. He has 2 children, a 7-year-old and a 4-year-old that he both cares for. His entire family pretty much lives in the state of Georgia. He has his GED and is also in the process of training to get his forklift certification. He was working at the Duracell warehouse for about 3 months before his incarceration, and he is under the impression that he will be able to go back. So he does have gainful employment upon his release. He's a lifelong Georgia resident. He does have an address off of Arlington Avenue, which I can put in the chat if that is not the address that is reflected in the record that the court has. He is married, and that is his emergency contact as well. So he has quite a lot of ties to the community. This is an incident where he has been in custody now for 101 days is the count that I looked at as of this morning, for a misdemeanor amount of marijuana, criminal trespass, and the firearm during the commission of the crime. We would be asking for a UJR on the marijuana and the criminal trespass, and then we would be asking for a $2,500 good bond on the firearm by a convicted felon. During the commission of a crime as well, simply because we know that that is not UJR eligible. I do note that he is also being held on a VOP. That hearing, I believe, last we checked, is scheduled for June the 12th with Judge Ingram. So we are optimistic that we will be able to get him hopefully home to his wife, children, and pending job that he has.
So what we have is a Magnolia Drive in Jonesboro. Is his address in Jonesboro, the Arlington, or is it in Fulton?
It is not, Your Honor. I will put it in the chat so that it can be added, and I'll also file a change of address.
So it's not in Fulton?
It is in Fulton. It is just not
It
that
is in
Magnolia,
Fulton.
Your Honor.
Okay, all right. What says the state?
Thank you, Judge. Well, based on Mr. Gilmore's history, Judge, the fact that he is on probation, does have a VOP, he's at a high risk to reoffend. So on the marijuana, we would ask $1,000. On the firearm by a convicted felon, we would ask for $20,000. On the criminal trespass, we would ask for $10,000. Total bond of $31,000, Judge.
All right, no drugs unless prescribed, no alcohol, no weapons. Stay away from 3887 Washington Road. That's the Washington Food Mart. It says allegedly 22.9 grams of marijuana, so it's $100, 10,000, and 5,000. 100, 10,000, 5,000. Best of luck to you, sir. You can leave the booth. Michael London. All right, Ms. Eustace, 22 CP 213078, position 8. 242 days without indictment. There is a $25,000 good bond as of January the 17th. Arson in the first degree and criminal damage to property. Free trial.
What position? I thought I heard 8.
Position 6.
6. 21 cycles out of Georgia, 2 out of Alabama, 13 out of Tennessee. 2016 conviction for forgery, 2016 conviction for identity theft, 2019 conviction for possession of a Schedule II controlled substance and possession of a Schedule I controlled substance, and 2022 conviction for entering auto, 5 probation violations, and 1 FTA out of Tennessee, and nothing further.
All right, go ahead, Ms. Eustace.
Yes, Your Honor. My client is over 200 days in custody now. His last bond was granted in January of this year. At that point in time, he had been in no bond since October of last year. He has not received a reduction past the 180 mark, which pre-COVID meant a lot. I understand post-COVID, it should mean even more. However, the state is not able to indict it at this time, it appears. My client has lived in Georgia for most of his life. His mother lives in the Augusta area. Her name is Nancy. This is an allegation in which it is brush fire. It is not a home. That's why he's charged with arson of lands, not property. It was in garbage cans is what is being alleged at this time. My client is actually, after I met with him, he's adamant about wanting to get into a residential program. However, he is unable to make any bond due to how long he's been in custody and due to some underlying MH issues that were around prior to his incarceration. However, he is receiving the appropriate medications and everything while at the jail and wants to continue on that path. We would be asking for as low a bond as possible. We would be asking for it to be under that $5,000 threshold. That way we would be able to submit him to a bail bond project once we can get him into that residential program that he so desperately has been asking for since I met him. But for him having a high bond, it's putting a bar on us being able to get him into a program. So that's why we would be asking for no more than 5,000 aggregate on the charges.
All right, go ahead, Mr. Marquez.
Thank you, Judge. Well, in this case, Mr. London does pose a danger to the community, and despite the defense's argument that yes, it's arson of lands. However, we all know, just based on our own experience, that arson of lands, for example, under a bridge, can cause significant damage to the community and slow traffic down.
And Your Honor, I would object to that. This is not the facts in this case, and it's not relevant to this.
Go ahead, Mr. Marquez.
Thank you, Judge. So the state would ask for the bond to remain the same. I mean, it's only been since January, and granted that the state has not indicted this case, so I will leave it up to the court's discretion.
It's been 242 days. So no drugs unless prescribed, no alcohol, no weapons. You're going to have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, including mental health, employment, basic life necessities, as long as you supply the name of your employer, proof of employment, schedule, and the exact location you're going to be working. Also, I put mental health appointments. If picked up on the hold, you'll have 48 hours to have that ankle monitor placed on your ankle. See, no drugs, no alcohol, no weapons. Sorry, I'm trying to read from my previous order. Stay away from 3040 Piedmont Road in Atlanta, Georgia, and stay away from 2990 Hardman Court in Atlanta, Georgia, and stay away from 3004 Piedmont Road in Atlanta, Georgia. And he's going to live in Fulton County. Is that right?
Is he allowed to go anywhere in Atlanta, Georgia, Judge? Also, hi to everybody just arriving. We are doing some manning and word games. Also, I just got my drink out of the freezer. It is how I personally believe the slushie was invented. So it is at the point where it is like slightly slushy. And I believe the person who invented the slushie must have had this happen at one point, because it is so delightful to drink, but it's like a 30-second window before it's frozen. Just always thought about that. And well, you guys know I don't drink alcohol. I just get funnier as everybody else gets drunker. So I don't drink alcohol. I drive. I drive around drunk people a lot. I don't mind dealing with drunk people. God, me going through a roadblock is hilarious. I'm like to the cop, I'm like, these fucking assholes are super drunk. I gotta get them home. And they're just like, oh, good luck to you guys. Peace out. See, it's like slushy. Anyways, it is a little slice of heaven. When I was younger, aka, this is something I would still do to this day. You get a slushie from 7-Eleven. We have 7-Eleven here. We also have other stores, but 7-Eleven. And then I would buy the sour keys that are like the big ones, and I would put them in the slushie and leave them in there for the first little bit of drinking the slushie. And then you pull them out and they're a little bit soggy, but not really. They're mostly frozen. Oh, love it.
Right.
Yes, Your Honor, because we're going to be trying to get him a program in Fulton County.
Okay. So 7,000 count 1, 5,000 count 2. Best of luck to you, sir. And I've put his name on my list. All right. What about Keith Lofton? Keith Lofton.
Don't see him in a booth yet.
Keith Lofton, if you're there, raise your hand. Nope. All right. What about?
Oh, they all got to share the same booth. I put a message in the chat. They all
okay.
Have to share the same booth.
All right. DeMarquise Yarber. All right. There we go. It's position 18. No bond since March the 1st. 23 CP 216560. 102 days without indictment. Fleeing or attempting to elude a police officer. Reckless driving. Failure to obey a stop sign. Receipt, possession, transport of firearm by a convicted felon or first offender. Also, 23 CP 216592, 102 days without indictment, no bond as of March the 1st for aggravated assault.
Levin Cycles, 2019 conviction for possession of a firearm by a first offender probationer. Open cases, 23 CR 001-140F, 23 CR 001-141F, and 23 CR 00142F. Those are all for battery family violence. And then 23 CR 001-135F, that is for battery family violence and criminal damage to property. And nothing further.
All right. Go ahead, Ms. Eustace.
Yes, Your Honor. My client is 24 years old. He turned 24 last month while in custody. He's been in Georgia his entire life. His family is here, mother, siblings, essentially the entire family. He has 3 children, a 3-year-old, a 2-year-old, and a now over 5-month-old, but at the time of his arrest was a 5-month-old. He's gone to the 11th grade and was employed doing labor staffing prior to being arrested. It was across from Peachtree as a temp service. He does think that he can go back. It was where they were doing housekeeping and linen washing. He'd been doing that for about 3 months. He does have a good address on file. It's the Maury Avenue address. He's lived there for 8 years with his mother, little brother, sister, and 2 of the 3 children. The complaining witness does not live there, and that is not the incident location. They do share a child together, so we would be asking, especially because today is past his 90th day, it's day 102 by my count, that he be granted a bond. He is okay with no contact, however, would ask for there to be the permission for him to see his young child that he shares with the complaining witness through a third party. And that request, he would ask for his mother, or if you don't need a specific person, that it would just be anybody, so long as he would be able to see his child. Both of these cases are at the 102-day mark, so he is legally entitled to a bond. We would be asking for position number 18 on the felony fleeing, 1,000, reckless driving, UJR, failure to obey a stop sign, UJR, receipt, transport, or possession of a firearm, 1,000. And then on the aggravated assault in position number 19, we would be asking for a $2,500 bond.
All right. Go ahead, Mr. Marquez.
Thank you, Judge. Can you hear me okay, Judge?
Yes, sir, I can.
Okay. In this case, because Mr. Yarber has several open cases, and of course, we believe that he is a danger to the community and that he is likely to reoffend if released from custody. On the first position 18, on the fleeing or attempting to elude, we're going to ask the court for $2,500. For reckless driving, $2,500. Failure to obey a stop sign, $1,000. Possession of a firearm by a convicted felon, $20,000. And on the aggravated assault, $30,000. And should there be contact between him and the victim for purposes of the child, any custodial exchanges, we ask that be done at a police station, and the third party be approved by both parties prior to any contact being made, Judge.
All right. Position 18, no drugs unless prescribed, no alcohol, no weapons. 2,500 count 1, 2,500 count 2, UJR jail for the failure to obey a stop sign, 10,000 for the firearm charge. And we'll go ahead and put the ankle monitor on this one, paid for by the county with a 24-hour curfew, court, lawyer, medical, employment, as long as you supply the name of your employer, proof of employment, schedule, exact location you're going to be working. On position 19, no drugs unless prescribed, no alcohol, no weapons. Stay away from 1002 Ira Street Southwest. No further contact with China, CHYNNA, Oliver, OLIVER. You have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, employment, as long as you supply the name of your employer, proof of employment, schedule, the exact location you'll be working. Absolutely no contact with Miss Oliver. I can't order her to let you see the child if you haven't legitimated the child, but in the event your mother or someone else can talk to her, sir, you cannot call her for no reason whatsoever. A third party has to reach out to her. They can't harass her. They can call her and ask for visits, and that's it. Am I clear? Give me a thumbs up. Thumbs up. All right, $30,000 good bond. Best of luck to you, sir. You can leave the booth. Keith Lofton. Keith Lofton.
I'm sorry, Judge. Can I get clarification on 19? I missed that bond amount. My internet blipped out. What's that bond on that charge?
I said 30,000.
Okay, thank you, Judge.
When she's saying Keith Lofton, my mind automatically goes Trent Lofton, who is one of the lawyers in Texas that we used to watch quite a bit. You guys should know I'm obviously against drunk driving. I don't drink, and therefore I don't drink and drive. But I also I go pick up people all the time. I'm well known as the person like my sister can call, my friends can call. Doesn't really matter what time of night it is. I'll come get them. I don't need sleep. Y'all know me. That's not my main concern. So, it is it's hard. I mean, we live in a very walkable city, but still people do stupid things. I personally think that drunk driving should be very, 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 very strictly prosecuted and handled. You know, what they could do is take the way that they treat pot crimes and just shift that attitude to drunk driving and then leave the pot crimes alone. And honestly, I think we would be getting somewhere, to be honest with you, because they look at people that deal pot like fucking crazy. And then, oh, drunk driving, whatever.
Keith Lofton.
Your Honor, that's Zachary Anderson's in 3 South, booth 2 right now.
Okay, well, let's get this one. Tony Hunter. Tony Hunter. Nope. All right. What about Andrew Wells? Which charge are we talking about, Mr. Morrell? Is it?
Mr. Morrell is currently driving home from the dentist's office.
He's here.
Yeah, I know he's logged in, but he alerted me in advance that he's listening in, but just because he's still on his way home, he doesn't want to do court while in a moving vehicle.
Gotcha. All right. So we don't have Keith Lofton, right?
Your Honor, he's on 3 South. Hey, Mr. Anderson, tell Keith Lofton to come inside the booth. Anderson, tell Keith Lofton to come in the booth. Thank you.
Thank you. All right, Ms. Eustace, this will be your last one, so you can go for your verdict, or hopefully you'll get one.
Thank you, Judge.
All right, Keith Lofton, that's you? Thumbs up. All right, we got you. Position 7, 22 CP 213271. Keith Lamar Lofton, 235 days without indictment, $12,000 good bond as of October 18th, 2022. For receipt, possession, transport of firearm by a convicted felon or first offender, willful obstruction of law.
Honestly, sometimes she says these things and my brain like doesn't even calculate it. 235 days without indictment. What if they don't indict? Like what? I do not understand the I don't understand what the long game is here, what the end game is, what the play is. It's very odd to me because it's not it's obviously a stance taken by the prosecutor's office in terms of how they go through things. I mean, I don't get it. I really don't get it. Also, just as an aside, if you think they're all criminals, wouldn't you catch more crime if you let them out and then sort of followed up on that as opposed to just kept them in jail? So they don't have 90 days or dismiss. They have 90 days and then they're absolutely entitled to a bond, which is what most of these hearings are. So most of these people came in and were not given a bond or were given a very high bond when they first started. Again, let's remember, Dismissal Dan, given the big D, is a contiguous county to this county of Fulton County. Clayton County and Fulton County are contiguous counties. They touch, okay? So literally where you are driving or where you are when this happens can have a huge impact on how your life, basically. And I'm not saying that there aren't some people that need to be in jail. That I'm not saying that. But seriously, what the fuck? Like the pot crimes, all that, the cost of those people being in jail, And the likelihood of their sentence being longer than they've currently spent in jail is so low that I don't understand. Also, there's no R, mayor, or Y.
Law enforcement officer, disorderly conduct. Pre-trial.
3 cycles, 38 out of Georgia, 1 out of Alabama, 1 out of Mississippi, 3 probation violations, 3 FTAs, 5 probation violations, aggravated battery and robbery conviction 2002. He has an open capital offense out of Fulton County, 21 CP 204424. Nothing further.
3 North, booth 3, get your head up. 5 North, booth 4, get your head up. Everybody sit up. 3 North, booth 3, get your head up. All right, go ahead, Miss Eustace.
Yes, Your Honor. As you mentioned, my client has been in for over 200 days at this point. I would like to note that his wife, Anyana, and Ms. Lofton is also on the Zoom to show her support. This is an incident that happened quite a long time ago, and you did hear that he does have another pending case in Fulton County, in which at this time there is a no bond. With him being held on that other case right now, we would be asking for a bond to be issued low on this. We would be asking for the transport of a firearm because that is not UJR.
Lady in red. Wait. Lady in pink. I'm just kidding. Thank you guys. I love this shirt. Especially because it's got thumb holes built in. It's my kind of shirt.
Are eligible to be 1,000 on the obstruction and the disorderly conduct. We would be asking for UJRs. He is going to be living with his wife and children in Alabama, should Your Honor allow that. I do have an address. It is my understanding that he does not have a specific reason besides court that he would really need to be coming back into the Atlanta area, that he would just be coming back and forth for court, but his primary residence would be in Alabama, where he has lots of family, he has gainful employment that is waiting for him there, and he would be able to have that support system that is so desperately needed once that we can address the other charge that is holding him in on another case that is not calendared right now. But again, some of those charges are in a no bond status, and he has been in for over 200 days. So we would be asking again for the UJR on the 2 and $1,000 on the firearm.
All right. Go ahead, Mr. Marquez.
Thank you, Judge. Well, because this particular defendant has a capital offense case pending, the state would ask for a very high bond on this case. I'm sorry, on the first charge, $30,000, on the second charge, $3,000, on the third charge, $3,000, and on the disorderly one.
Okay, guys, the word was swoon. The word was swoon. We did not get that one. It was swoon. Ika, I will come and let you in a minute.
$1,000. That's our position, Judge.
And Miss Eustace, he's got no bond on the other case, right?
Yes, Your Honor. And bond, I just wanted to be clear, I did believe bond was granted October of 2022 on this case. He just has not had a reduction since, and that is what we're on the calendar for today.
Right.
But also just wanted to clarify that I believe that Ms. Roberts indicated some FTAs. His wife actually came into Atlanta and handled those to get them cleared off. So I don't know if a new GCIC just has not been run to reflect that change.
Okay. No drugs unless prescribed, no alcohol, no weapons. Stay out of Fulton County unless you're here for court or to see your lawyer. You're going to have an ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical, employment, as long as you supply the name of your employer, proof of employment, schedule, exact location you're going to be working. But stay out of Fulton County, sir, unless you're here for court or to see your lawyer. So we'll do 4,000 count 1, 500 on count 2, and 500 count 3. So $5,000 good bond. Best of luck to you, sir. Zachary Anderson. Thank you, Ms. Eustace. Good luck.
Thank you.
Zachary Anderson.
He's coming in now, Your Honor.
Okay. 3 North, booth 3. 3 North, booth 3. Can he hear?
Your Honor, he's on the mental health floor. That's as far as.
Okay. All right. But can he hear?
He can hear you.
Okay. I want to make sure he can hear. All right. Zachary Anderson. All right. Mr. Cho. I've already put this one in. Anything?
Oh, you know what would be a really funny way for a judge to decide if people were listening or not? Imagine at the beginning if she did a Simon Says. The game of Simon Says. Or a Hokey Pokey. You know? Put your hand together and you turn it on. And that's what it's all about. Hi, Ika. Seriously, can you imagine? Like, okay, Simon Says, put your hand on your head. Simon Says, put your hand on the screen. Simon Says, sit your ass down. Simon Says, no bond for you.
Over 200 days in my email, and this one was in red too. Position 25, 22, CP 214-959, 600 days without indictment. There is a $1,250 good bond. Arson in the first degree, criminal damage to property. Free trial.
39 cycles, 2013 conviction for act assault and criminal attempts to commit a felony. 39 cycles.
First degree, criminal damage to property. Free trial.
39 cycles, 2013 conviction for act assault and criminal attempts to commit a felony. 2017 theft by shoplifting conviction. 2019 criminal attempt to commit armed robbery conviction. 2020.
Raven, I love it. We sort of, we understand the game. Here's the thing. We actually came in and we've won every single, woo, it was twice. Good job. We've won every single one except one. And we do have different ways of doing it. I don't think everybody understands, but some of us do. So Sheena, we are going to make being a math teacher awesome next year. Seriously, we're going to get, yeah, I already see it. Also, the rice is on, the beans have 56 minutes. This is Kitty, this is Ickadoodle. Ickadoodle is over 17, I think she's 17 years old now, 16. She's old. And she is a lovely cat. Anyways, let us continue with playing the game and listening to Judge Manning give us those beautiful pre-trials. Seriously, soothes my soul.
2020, 2021, 2023, all theft by shoplifting convictions. Open interference with government property, 23 CP 218360. Nothing further.
Go ahead, Mr. Cho or Ms.
Your Honor. Your Honor.
Ma'am.
He's also on the add-on calendar.
Oh, wait a minute. Did I miss? Oh, yeah, I did miss one. I apologize, Ms. Fialco. 23 CP 218360. This is interference with government property. There is a $7,500 good bond as of May the 10th. Sorry about that. Thank you, Ms. Gandy. Go ahead, Ms. Fialco.
Your Honor, I apologize for interrupting.
She's a very skinny cat. She's always been skinny. Nana, it's mostly because Nana refuses to feed her. She withholds food from the cat on purpose. Right, Nana? I'm kidding. She doesn't. Because we had the dog today, she was in a different room. But she is very, very thin. Ika, I'll put the food down, honey. Hold on.
As well, but I'm actually here for the 23 CP case, the add-on.
All right. So Ms. Fialco's got one. Ms. Rhonda's got one. All
Yes.
right. Go ahead, Ms.
So
Go ahead,
if
Ms.
I
Fialco.
just briefly will say, so I'm here for 22 CP 214959. Mr. Anderson has a UJR2 pad. There are county holds and the case with Ms. Rondon that are holding him in. I am here to answer any questions you have about that case, but we'd ask that UJR to pad remain in place.
Yeah, see, I signed that order March 21st. So the other case, Ms. Rondon's case is one that's holding them in. So go ahead, Ms. Rondon.
Yes, Your Honor. And I'm asking for a UJR to the PAD program. He has been accepted into PAD. He already has a UJR in the 22 CP case to that program. The only reason he has not been released to the program so far is the bond in this case and 2 county holds. It's my understanding that the DeKalb hold has been cleared. It's just not updated in the system yet. And that Mr. Anderson is going to court July 11th to take care of the Atlanta PD hold. Once that's taken care of, there should no longer be any county holds that hold him back from going to the program. And I'm asking for the 23 CP case to be a UJR to the program.
All right. Mr. Marquez.
Thank you, Judge. Well, just looking at the facts in this case, I think it would be appropriate to lower the bond on the interference with government property, although the state would ask for, at the very least, a $5,000 bond, just because, given Mr. Anderson's history, and granted there may be some MH issues along with some other things, but I think that's reasonable at this point.
All right. So did not, Ms. Fialko, did I put amounts or did I just do a straight UJR?
I believe it was a straight UJR.
Okay, so we'll
Sorry to interrupt, Judge. I know it's rude, but the word there was grade. The word was grade. I blame Sashina for that because she's a teacher. Actually, I still believe that this takes words that we say a lot, and I don't know why. I don't know if it takes words I say or the chat says or what, but I laugh. Because we all know my grades were shit.
leave that one on position 25. Ms. Hunter is a straight UJR to pad, and I signed that order for the release to pad on March 21st, 2023. I don't know, Ms. Fialko, if it's going to be a different person. If it needs to be updated, you could just shoot that to me. So we'll leave that as it is. And what I'll do on the other is, yeah, still UJR. No drugs unless prescribed, no alcohol, no weapons, UJR to pad only. No further contact your co-defendant. Dylan, I can't even read my own handwriting. Dylan Bellard, Bellard. You're gonna have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, employment, and participation in a program and anything in pad. You just have to supply the name of your employer, proof of employment schedule, exact location you're going to be working, and also the program that you're participating in. Best of luck to you, sir. You can leave the booth. Don't disappoint me.
And Your Honor, that
Thank you, Your
concludes
Honor.
my business.
He's trying to say something up there. Look at him. He's like, wait. First of all, oh my God. You want to talk about how to motivate me? If Judge Manning said that to me, I would do anything not to disappoint her. I'm serious. Like, that one spoke right to my heart. I'm going to listen to it again, actually. Disappoint me, kitchen. Don't.
And also the program that you're participating in. Best of luck to you, sir. You can leave the booth. Don't disappoint me.
And Your Honor, that
Thank you, Your
concludes
Honor.
my business.
Ms. Fialko and Ms. Rondon will reach back out to you. Thank you. All right, what about C? Did Tony Hunter come in? Tony Hunter, nope. What about Jerry Reynolds? They'll call you. They'll call you. They'll call you. Thank you. Let's see, Jerry Reynolds. I don't see a Jerry Reynolds. What about
Jerry Reynolds has his head
down.
Hold on one second. Court 2.
I feel so bad for that guy. He just gave up. If you guys noticed, I posted a video earlier today of a guy freaking out in court. Very similar to that. I do think it's hard when they can't talk, but it is, again, for their own good. Some judges do it with a little blurb at the beginning. Some judges do it by muting them. But they're really trying to help them. I know that people in the defendant's position don't believe that. They think if I could only tell them what I need to say, they would understand. But that actually only really works in front of dismissal Dan, as far as I can see. Everybody else, nobody else, you shouldn't talk. Even in front of dismissal Dan, he's made a decision. You're getting dismissed not because of what you say, but because of what he decided. Also, you guys just wrote chases, and I was like, is there a fucking chase? Oh my God. There's not. I don't think.
Everybody's talking at the same time.
Jerry Reynolds is in 3 North, booth 3.
Okay, so he's the one who's not waving. Okay.
Yes. Your Honor, we have a pending ex parte in this case, but it's been so long that we're still asking to be heard on bond.
Okay. All right. Yeah, we got a $39,000 good bond as of January the 26th. 22 CP 213071, 244 days without indictment, aggravated assault against law enforcement officer, willful obstruction, felony, and criminal damage to property. Pre-trial.
What's the position number?
5.
First arrest.
All right. Go ahead, Ms. Farasi.
Thank you, Your Honors. Mr. Reynolds, as you said, he's been incarcerated 244 days. That's without an indictment. He is a high school graduate.
First arrest? Indicted for 244 days, or without indictment for 244 days? What the motherfucker? This is crazy. That's funny. Gino 007 Abel. I don't know why that's not how your name is in my mind, but when I say it out loud, that's how I say it. Thank you guys. I really do appreciate you liking the color. I didn't eat toast with butter and confectioner's sugar, but I did eat toast, butter, brown sugar back into the oven, re-toasted. Delicious. Oh, cinnamon. Also, you need to have cinnamon. Honestly, it is all entirely about economic ability, because if you hire a lawyer, they seem to be able to get you out while you wait. It's literally baffling to me. And I feel bad for Judge Manning. I really like to hear her say how because I do this too. What I used to when I was in administration. I would color and bold and make things really big in emails if I was like, hey, dumbass, you didn't do this and I already asked you to do it 52 times. But you can't really say that in a business. So you say, as per my previous email, noted below, please confirm that you have executed the requested directions or something like that.
Your Honor, we do have an address for him. His father had confirmed that address, but his dad is a truck driver, and I haven't been able to get in contact with him very recently. But his dad does have a house in Atlanta that he stays when he's not on the road. Mr. Reynolds himself was originally from Ohio, and he's been in Atlanta the last 4 years now. He did, at the time of his arrest, have a job in East Point at an Arby's, and he had that job for a solid year. Your Honor, he does have severe mental health issues. That's why we're getting him evaluated. We're also trying to get him into a program. And through no fault of Mr. Reynolds, he has been shuffled around through 3 social workers. And so I think he's kind of fallen through the cracks because of that different transferring of the social workers. But he's soon going to get a new social worker. And then once we have that new social worker, I'm going to get on them about trying to get him into a program. Your Honor, we are asking for a bond. We're asking for significant reduction just because he's been sitting. The state has not done anything with his case whatsoever. We had a prelim back in January, and we're looking now but what are we in? We're in June, and there's been no movement on this case whatsoever. This is his first arrest. He's only 18 years old. He's a very young kid. So, Your Honor, we're asking for a bond not to exceed 5,000. That'll give me a chance to apply to the bail project, or hopefully before then we'll get the evaluation back, or we'll get him into a program. But we just need a significant bond reduction. Thank you.
Go ahead, Mr. Marquez.
Thank you, Judge. Well, in this case, Your Honor, because there are MH issues and the charges are substantial, especially against law enforcement, we believe that Mr. Reynolds is a risk to the community and a danger to the community. So without having him evaluated, I know the PD already addressed that to some degree. I would just ask the court to leave the bond as is.
I'm sorry, I'm a little confused. If it's his first arrest and therefore his first interaction with the justice system, how are you so concerned that he has serious MH issues? This is the wrong venue to deal with this for him. It doesn't make any sense. It costs exorbitant amounts of money for this hearing, for his continued incarceration, all of these different things. So I don't get it. I don't get it. I don't get it. It's fucking pissing me off. Merge is no good. There's no G.
Is.
All right, let's see. No drugs unless prescribed, no alcohol, no weapons. No further contact with Sheldon McDonald, Sheldon McDonald, or D. Coleman, unless in their official capacity as law enforcement. And now the house now he's going to live in is in Fulton County, right? Because I know I had stayed out of Fulton County previously, but sorry for us.
It is in Fulton County, Your Honor. So we would ask that condition not to take an effect for this case.
Okay. Have an ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical, including mental health and employment and basic life necessities, or any sort of program you get him into. As long as he supplies the proof of employment, name of the employer, location, and the schedule. Stay away from Hilliard Street and Edgewood Avenue. Let me see, 1 second.
Yeah, just so you know that the weapon alleged was a bottle. It wasn't a gun or anything of that nature, a knife or anything of that nature. It was a simple bottle.
Right. Looks like the bottle, and he shattered on when he hit the officer inside of the head.
Okay, well, I was just gonna do a little freak out, but maybe, yeah, you don't hit people on the side of the head with bottles unless it is a movie prop. Reminds me. Oh, that's what we'll watch after this. I'm gonna show you guys. Yeah. Jolly, if you haven't already heard about my love for that channel, I love those guys. And they did this really fun thing where they bought all these movie props from the Netflix supply place and smashed them on each other. It was great. I'll show you a little clip after this. But again, we've heard of very, very, very worse things. I mean, we're getting people with child porn charges and stuff getting less time than this altogether. Like, I don't get it. Like, is it just easy to incarcerate people, easier to deal with it that way as opposed to, Also, Raven, the command did change its try now, by the way.
All right, let's see. 8,000 count 1, 8,000 count 2, 1,000 count 3. 8, 8, and 1. Best of luck to you, sir. I think maybe we could just remove that one from there. I don't know if he's going to get up and leave. We may be able to just remove.
It's my channel and I'll do as I want to, do as I want to, do as I want to. You could do it too if you started 1, 2, do.
Remove that booth.
Maybe some you might want to tell him to leave. He's.
Sir, you can leave the booth, Mr. Reynolds.
Thank you, Your Honor.
Okay, thank you. Hopefully, well, I guess he heard. Thank you. Ms. Rondon, if you want to leave, you can too.
Yes, thank you.
Thank you.
Your Honor,
Have a
may I
good
be
night.
excused as well?
You too, Ms. Fiacco. Thank you. We kind of got this down to a science. 6:05. We're almost done. This is amazing. All right. What about Tony Hunter? Can you come in? Tony Hunter. Nope. Okay. What about Levi Rivera Martinez? And we don't need interpreter, right, Ms. Rosenhuber?
That's correct, Judge.
Okay. This is position 4. There is a $35,000 good bond as of March the 9th, 2023. Make sure I got all the C. Hold on, make sure I don't call off some that have been dismissed. 16, 14, 18, 17. Okay. Theft by receiving stolen property, felony, aggravated assault against law enforcement, criminal damage to property of the second degree, criminal damage to property of the second degree, willful obstruction, misdemeanor, no insurance, attempting to misrepresent a tag, failure to yield the right of way to an emergency vehicle, reckless driving, failure to obey a traffic signal or stoplight, driving hit and run, duty to stop and return to the scene of an accident, and driving, fleeing, and attempting to elude. Pre-trial.
Showing 4 not convictions, 4 cycles, 3 out of North Carolina, 1 out of Georgia, no felony convictions listed.
All right, go ahead, Ms. Rosenhuber.
Thank you, Judge. Mr. Rivera Martinez is 29 years old. His most recent address is still good, and it's in Cumming, Georgia. He would be staying there with his uncle. He's lived here in Georgia for the past 1 to 2 years prior to his arrest. He made it to the 11th grade and was most recently doing pool construction work. At this point, I believe he's been in 294 days without indictment. He does have that ICE hold. We've already had the preliminary hearing, so we're just back on for another bond reduction hearing. We're asking for a significant reduction given the amount of time he's been in custody and his limited criminal history. My recommendations in the order that the court called the counts are as follows. Count 1, 1,000, count 2, 2,000, 3, 500, 4, 500, skipping to count 7, 1,000, 8, UJR jail, 9, UJR jail, 10, UJR jail, 11, 2,000, 12, UJR jail, 13, 2,000, and 15, 2,000. And I have that's a total of an $11,000 bond. Thank you, Judge.
All right. Go ahead, Mr. Marquez.
Thank you, Judge. In this case, Mr. Rivera presents a significant danger to the community. In this case, if the judge will remember, or if the court will remember, this is a driving hit and run, fleeing the scene of an accident, aggravated assault against an officer. He does have a $35,000 bond. He hasn't been able to make it, but we believe that bond is sufficient, and we would oppose any further reduction in bond at this time.
All right. Let's see. 6. Got everything here. Okay. No drugs unless prescribed, no alcohol, no weapons. You can have ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical, employment, as long as you supply the name of your employer, proof of employment schedule, exact location you're going to be working. Also, sir, stay out of Fulton County unless you're here for court or to see your lawyer. That's the only reason you come to
Amy
Fulton
had
County.
it.
Get gas.
Judge, for a second. Amy had it. It was Mercy. So, guys, I'm just going to tell you, this is why my theory on the guessing, I think, makes more sense. If you guess the entire alphabet, from A in order, the first 3 guesses, you eliminate 15 letters. And you then still have 3 guesses left to do, to sort out more specific guesses. I know I don't know. That is how I play the game, because to me, it's like you can guess randomly, but if you utilize the correct letter spaces with the correct letter in your guesses, you actually don't eliminate more letters. It makes more sense to eliminate the letters first. Do you know what I'm saying? Anyways, let's continue on. Mayor, I'm glad that you went and did you get it checked out? That I hope so. But again, I don't even care. I just really, you say the alphabet in your head. I know I do the alphabet as well when I'm doing it. But what I'm saying is, if you start and do the first, whatever, 15 letters of the alphabet, it's very easy to see what's left and what you could do. But that's how my brain works. We all know my brain's weird.
Don't get a flat tire, don't stop for lunch, straight to court, leave. Do not stop for any other reason when you come to Fulton County. And I have on here, they must reside at 1885 Valley Way Road in Cumming, Georgia.
I get starting with the vowels. What I think happens though, and this is just my experience, is that people get confused about, like, they decide they want to guess and they see the letters where they are and they for some reason think that they should put them there. It's just hard to make your brain forget about it. So how I personally play is my first two guesses at the very least are usually just always the same, and then from there, but this is you guys playing, so you can do what you like. The other way I also play is with Wheel of Fortune guesses, RSTLNE, and whatever the vowel ones is. Also, me wearing a bikini, that is definitely something that might happen one day.
Georgia 30040. No further contact with Trooper Jordan Buffington, Evan Johnson, or Sergeant Salvador Salvador Ortega Ortega, unless it's in their official capacity. So we do 2,000, 5,000, 1,000, 1,000, 2,000, 250, UJR jail, UJR jail, 3,000, UJR jail, 4,000, and 5,000. You need me to repeat that, Miss Hunter? Miss Rosenhover?
I got the numbers, Judge, but I'm still adding them up.
But now we have 4 out of 5 letters, right? So rhymes? No. Yeah, that could be it. Anyways, my brain is always working on the words as I'm doing it. I'll keep it going.
All right, did you get them, Miss Hunter?
Yeah, I did.
All right, best of luck to you, sir. You can leave the booth. Stay out of Fulton County.
Thank you, Judge, and that concludes my business, if I may be excused.
Yes, ma'am. Have a good one. What about Tony Hunter? Did you come in, Tony Hunter? No Tony Hunter yet. Okay. What about Jameis Barnwell? All right, Mr. Barnwell. It's 21. We got 23 CP 216626. Jameis Dantrell Barnwell, 101 days without indictment.
I think it's brine. No, it's not, because BRINE, the I's in the wrong spot, can't be that. And it can't be rains. E is in the wrong spot as well. Can't be dinner or diner or finer because the N is in the wrong spot.
What is this? No bond, possession of firearm by a convicted felon and reckless conduct. Preach! Raw!
Yes, 32 cycles, 34 out of Georgia, 7 out of Florida, 1 out of North Carolina. 2018, 2019 theft by shoplifting conviction. 2012 removal or attempted removal of a weapon from public official conviction. 2012 theft by taking and financial transaction card theft. 2004 criminal solicitation. 2001 possession of cocaine. 2001 possession of a controlled substance. 2000 aggravated assault and robbery. 3 FTAs, 6 probation violations.
Go ahead, Ms. Beck.
Thank you, Your Honor. Mr. Barnwell is 42 years old. He received his GED. He's a lifelong resident of Georgia. The address that is on file is still a good address for him. He lives there with his mom, and the address has been verified by Ms. Collins. We are asking for a UJR for the reckless conduct and bond not to exceed $7,000.
N's not
for
in the
other
right spot.
All right, and that's Ellenwood, right?
Yes, Your Honor.
Okay, go ahead, Mr. Marquez.
Thank you, Judge. Judge, the state is in the position that Mr. Barnwell represents a significant threat to the community. He is likely to reoffend if released on bond. However, since he is entitled to a bond, the state would recommend on the possession of a firearm by a convicted felon, $30,000, on the reckless conduct, $2,000, total of $32,000.
All right. No drugs unless prescribed, no alcohol, no weapons. Stay out of Fulton County unless you're here for court or to see your lawyer. Don't get gas, don't get anything to eat. Court and see your lawyer. Stay away from 1020 Spring Street Northwest, which is fine. That's in Fulton County. You're gonna have an ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical, employment. As long as you supply the name of your employer, proof of employment, schedule, and the exact location you're going to be working. 10,000 count 1, 5,000 count 2. Best of luck to you, sir. You can leave the booth.
That concludes my business, Your Honor. May I be excused?
Yes, ma'am.
Thank you.
What about Demetrius Madison?
It was Inter, Inteer, Inteer. Now, this is a great time for everybody to go ahead and catch up to the live stream. That means if you use voice to text, if you sometimes pause things, if you don't have YouTube Premium and you can't watch in the background, every time you step away from the live, it goes back a tiny little bit. And when you come back, you have to press that little live button to get right back up to live. This is a great time to come live so that you can be playing with us all.
Oh, there you are. All right, position 16. This has a $1,000 split bond with $5,000 on the marijuana less than an ounce, $5,000 on misdemeanor theft by taking. Got aggravated assault, possession of firearm by a convicted felon, another aggravated assault at no bond. 23 CP 216-539, Demetrius Madison, 103 days without indictment. Free trial.
And Your Honor, just to be clear, you said 5,000, it's 500 on 500.
Oh, I'm sorry. Yes, okay. It's been
Well, that's a big difference. 500, 500, 5,000, 5,000. That's a great idea. Med check, med check, med check. Folks, what that means is, if I can send that message back in time, the pause people will hear it. Well, my theory is the pause people must be looking at the chat because their chats are live. Med check, med check, med check. Take your meds. What that means is, do you take meds? If you do, take them. Or think about when you should take them. If you don't, come to the chat. Tell us what that's like. We would like to see it. But you know what I mean? Like, I think that both the live, like people listening, if they're guessing, they should see the live chat.
a long day. It's been a very
I
long-
understand, Your Honor.
Yeah, 500 on each of those. Thank you so much. Go ahead.
I did not take note of the number of cycles, but he has 2 parole violations, 1 FTA, a 2003 capital offense conviction, and then an open case 22 CP 209405 for ag assault and possession of marijuana less than an ounce.
All right, go ahead, Ms. Correa.
Thank you, Your Honor. In regards to the open case that Madam Pretrial just listed out, that case does remain unindicted, and it's been unindicted for a year now. I just wanted Your Honor to make note of that, of the non-indictment of that other case. Mr. Madison is 36 years old. He's a lifelong resident of Georgia. His family is currently following along tonight's hearing through the YouTube link. I provided them with that information. The address reflected in Odyssey is a good address for Mr. Madison. That's where he would live with his wife and his sister. He was able to complete his GED. And at this time, I have received confirmation from his employer that his job is still waiting for him. Of course, he would not be allowed back at the incident location. He has been in custody for now 103 days without indictment, which means that he is lawfully entitled to bond. Mr. Madison is profoundly indigent at this time and would not be able to make a significant bond. So I'm asking Your Honor to set a bond that does consider the reality of Mr. Madison's situation. I'm asking Your Honor to consider setting a $10,000 bond. Thank you, Judge.
Go ahead, Mr. Marquez.
Thank you, Judge. Judge, this is a serious case. Mr. Madison is a repeat offender. So we are concerned that his propensity to reoffend is going to be high. We do consider him a danger to the community. He already has one capital offense. So we are asking that should the court set bond on the aggravated assault with no bond, that it would be a $100,000 and keep the other bond amounts as is.
All right. No drugs unless prescribed, no alcohol, no weapons. Stay away from 2176 Vesta Avenue. No further contact with Sonny. I can't read my hand. Is it a Creek or Creer? Greer. Good gosh, hold on.
Creer, C-R-E-E-R.
All right, yeah, that's what I thought. Okay, C-R-E-E-R and Audrey Stovall. Stovall. You can have an ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical, employment, as long as you supply the name of your employer, proof of employment schedule, and the exact location you're going to be working. Along with that, basic life necessities. And this has, it was allegedly 21 grams of marijuana. Let's see.
That is less than an ounce.
Yeah, and this has the Fairburn, right? Is where he lives.
Yes,
Fairburn. Okay.
That's right. It's less than an ounce. How many grams in an ounce? It's 28. It's 28.
All right. So 30,000, 10,000, 30,000, UJR jail and $100. 30, 10, 30, UJR jail, $100. Best of luck to you, sir. You can leave the booth. Thank you. What about Deshaun Rivers? Thank you, sir. Mr. Madison, you can leave the booth. All right, Mr. Gazzoli, there is a $46,000 good bond as of December the 15th on position 11, 22 CP 211946. 282 days without indictment, aggravated assault, possession of a firearm or knife during the commission of or attempt to commit certain felonies, possession of a firearm by a convicted felon, giving false information to a law enforcement officer. Pre-trial.
7 cycles, 2 probation violations, 2021 conviction for possession of meth with intent to distribute, and nothing further.
Go ahead, Mr. Gazzoli.
I'm not sure if he can hear you, Judge.
Sorry, Your Honor. No, I'm here. My mute button was
that's all right.
It was mid adjustment here. All right, thank you, Your Honor. Mr. Rivers is 25 years old. He has not found new housing since his incarceration.
Charles, you know I don't use grams in cooking. I use grams when selling weed.
Incarceration, Your Honor. He does have a good mailing address at 2265 Perry Boulevard, Building 8, Apartment 80, Atlanta, Georgia 30318. I've already been in contact with my social worker about trying to find some housing, especially once we get his bond to something that might be a little bit more manageable. He's a lifelong Atlanta resident. He has a wife, son, and sister who all live in the Atlanta area. Your Honor, before his incarceration, he was working at Down South Cleaners. which cleans homes and carpet. Your Honor, his bond that's currently set, as you mentioned, is 46,000. He has been in jail for the past 282 days, Your Honor, without an indictment. We're asking that his aggravated assault be reduced from 25,000 to 10,000. His possession of a firearm charge be reduced from 9,000 to 3,000. His possession of firearm by a convicted felon be 9,000 to 3,000. And giving false information be reduced to 500, which I believe would be a total of
It was stuck.
16,500.
All right, go ahead, Mr. Marquez.
Thank you, Judge. Well, in this case, we believe.
Let me reset the game and see if I can get it closer to live with us.
The defendant does have a high propensity to reoffend, that he is a danger to the community.
Actually, we're gonna go ahead. You guys did say stuff, but you didn't get it. It's how the guesses go in. Anyways, that's why you need to designate a guesser. And because sometimes they get stuck. Anyways, everyone catch up. Part of me wants to just wait in silence until nobody guesses anymore, but I'm just joking.
Large and to the victims. So we would ask the court to keep the bond as is.
All right. Once again, I'll note he's been in 282 days without indictment. No drugs unless prescribed, no alcohol, no weapons. No further contact with Lerayah, Lerayh Matthews. Stay away from 2265 Perry Boulevard. You're going to have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, employment. As long as you supply the name of your employer, proof of employment schedule, the exact location you're going to be working. You'll also need to supply an address where you'll be living when you get out on bond, sir. You have to supply an address where you're going to be living. All right. So we got 20,000, 5,000, 5,000, and 1,000. 20,000, 5,000, 5,000, 1,000. Best of luck to you, sir. You can leave the booth.
Thank you, Your Honor. I believe that concludes my business. May I be excused?
Yes, sir. All right, I've got.
I'm sorry, Your Honor. Did at the beginning did you announce that Mr. Jones was going to be held off until his hearing later next week?
Yes, sir.
Thank you, Your Honor.
Okay, thank you. All right. What about, let's see, Marquez Soul. All right. That's let's see. That is it's number 24, 23 CP 216690. 99 days without indictment, no bond as of March the 3rd. 1 count of aggravated assault. Pre-trial.
9 cycles, 1 conviction. That conviction is
So
for
many.
purchase, possession, manufacture, distribution, or sale of marijuana, possession of a firearm or a knife, and commission of a felony in 2009, and nothing further.
All right. Go ahead, Ms. Pinto.
Thank you, Judge. As stated by the court, Mr. Saul has been incarcerated 99 days with no bond, so he is entitled to a bond today. He's 31 years old. If released, he would reside on Epworth Street in Atlanta, which should be the address on file.
And if it's 1412, that's the incident location too.
No, his address is 1403, so I'll need to file that change of address, Judge.
Okay, yeah, because it had 1412 previously. Thank you.
But that at 1403 is where he resides with his mother and his girlfriend. He's lived in Georgia his entire life. His entire family is here in Georgia. He went to the 7th grade, but then did get his GED. We are asking for a reasonable bond for him. I spoke with the alleged victim today, who's actually his uncle, and I gave him the link. He was going to try to come on the Zoom, but it doesn't look like he was able to make it. There was some technology concerns. However, he did tell me that he is not in fear of Mr. Saul. He does want him to get a bond, and I do think he told that to the DA's office as well. But of course, ADA Marquez can confirm. So given that he only has one felony conviction, Judge, we are asking for a bond not to exceed 10,000 for Mr. Saul today.
All right, go ahead, Mr. Marquez.
Thank you, Judge. And thank you, Ms. Pinto, for that lovely introduction. I would actually, in this case, I don't have any information on the victim. So just based on the defendant's history, the only thing that would concern the state would be the safety to the victim and the community at large. So we would be asking in this case a $30,000 bond, no contact with the victim, at least until we can sort that out, that he do wear an ankle monitor and report for court as directed, Your Honor.
All right, no drugs unless prescribed, no alcohol, no weapons, no further contact with Howard Stinchcomb, Stinchomb. Stay away from 1412 Epworth Street, EPWORTH. You can have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, employment, as long as you supply the name of your employer, proof of employment, schedule, exact location you're going to be working. 5 North, booth 4. 5 North, booth 4. Is he trying to hear? Is that what he's trying to do? All right, so we'll make this a $20,000 good bond. Best of luck to you, sir. You can leave the booth. All right, I've only got two more cases.
May I be excused?
Yes, ma'am. Thank you. I got
Judge, if
Tony-
5 North booth 4, is he saying that he can't hear? He could go in booth 1.
Yeah, I guess I don't even know who it is. I think it's somebody who's already went. If you have already went, you can leave the booth. All right, let's see. Tony Hunter. Thank you, Mr. Hunter. Miss Bray. We got it's position
I'm here.
10, 23 CP 215404. 147 days without indictment. Tony Lamar Hunter, no bond as of January the 13th. Aggravated assault, armed robbery, possession of firearm or knife during the commission of or attempt to commit certain felonies, use of firearm by a convicted felon during the commission of a crime. Pre-trial.
19 cycles, 6 probation violations, 1 FTA. Open case 23 SC 187724. That is for aggravated assault, strangulation, aggravated assault with a deadly weapon, battery, family violence, terroristic threats, possession of a firearm during the commission of a felony, and possession of a firearm by a convicted felon. 2014 conviction for 2 counts of robbery. 2017 conviction for terroristic threats, and then a 2021 conviction for possession or transport of a firearm by a convicted felon.
All right, go ahead, Ms. Bray.
Yes, Your Honor. Mr. Tony Lamar Hunter is 29 years old. He is a lifelong resident of the Metro Atlanta area, Your Honor. But as Your Honor has taken into account the amount of days he has been in without a bond, he is in fact entitled to a bond. And I'm asking Your Honor to set a bond of 10, 10, 5, and 5 for a total of 30.
All right, Mr. Marquez.
Thank you, Judge. Judge, the state believes that Mr. Hunter is an extreme threat to the community, that he does have a high propensity to reoffend, that especially against the victim, and in this case, the circumstances of this case would lead me to believe that should he be released, he would also pose an extreme danger to the community at large. Therefore, the state will ask for $100,000 per count.
I think the issue is this guy does sound violent and dangerous, but the problem is it's just like the boy who cried wolf. When you waste all of your brouhaha on keeping pot dealers in jail, when you come to say this, it doesn't sound any different. I'm not any more scared. Like, you've wasted it. You've made me not react because you treat everybody the same. I don't trust your judgment. I don't trust that you actually know anything. It would be so different if he was like letting people go, being realistic in things, and then out of the blue goes, absolutely not, Your Honor. This person is dangerous and they need to be kept in jail on a high bond. It would be a whole different story. I don't understand why they don't realize that they devalue their arguments when they have the same standard policy for each type of person. it makes them look just stupid, to be honest, really. Like they're lawyers. I don't, if either they're being stymied at the higher office level or they're doing it themselves, but either way doesn't work and it doesn't help anyways. Doesn't make them look good. Nobody's like, wow, they just keep so many people in jail. That's so great. Like, no. No. So again, if they wanted to make a difference here, and I've said that before, exactly, which is why we like Big D. He does tailor the needs to every person, and it doesn't. And I love Judge Manning too. Judge Manning's been put in a hard spot here, right? Not only is she having to deal with people who are dealing with unindicted cases, but she's also dealing with a pretty big platform that she's being watched on. And I think the lawyers that appear in front of her, not the defense lawyers, but the prosecutors, are worried about the optics of that that happening. Honestly, and I just think it's cowardly, maybe cowardly. Yeah, that's what I think. Cowards.
Total of 400,000.
Are you gonna live at the Hateville address, Miss Bray?
Yes, Your Honor.
Okay. No drugs unless prescribed, no alcohol, no weapons. Stay away from 2471 Old National Highway in College Park. No further contact, with Demetrius Douglas, Douglass. You're gonna have an ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical, employment, as long as you supply the name of the employer, proof of employment schedule, and the exact location you're going to be working. Stay away from all travel lodge motels. 50,000, 50,000, 10,000, 10,000. Best of luck to you, sir. You can leave the booth. Andrew Wells. All right. What are we addressing? The misdemeanor theft by receiving stolen property?
Well, Your Honor, I had spoke with Ms. Markowitz about this. We've I was going to file an emergency bond hearing because we've recently had him admitted into the Baylor house. I've also have Ms. Markowitz instructed me to have my social worker who was able to place him into the into his placement inpatient treatment program. She is on the Zoom. She's listed under Raven Ross, Your Honor. She's one of our more senior social workers. She is more of a forensic social worker. So she deals deeply with cognitive behavior therapy. So we will be able to address this. So we're asking if all of his bond can be addressed so he can get into his program because he's going to go through Ebenezer's bailout program.
Let's see. All right. It's position 1 on the add-on 22 CP 208589 Andrew Wells. 409 days without indictment. There's a $61,000 good bond as of May the 9th, 2023. 3 counts of financial identity fraud, financial transaction card theft, possession of tools for a crime, possession of a firearm by a convicted felon, possession of a firearm during the commission of a felony, theft by possession of stolen mail, VGCSA, possession of methamphetamine. 2 more counts of financial identity fraud, reckless conduct, theft by receiving stolen property misdemeanor, and theft by receiving stolen property felony. Great trial.
What position was this, Judge?
1. It's one of the add-ons.
Oh, add-on number 1. Andrew Wells?
Yes, ma'am.
19 cycles, 2009 conviction for financial identity fraud and forgery, 2013 conviction for theft by taking and theft by conversion, 2012 conviction for unlawful for any person to purchase, possess, or have a controlled substance, 2016 conviction for theft by taking, 2017 possession of meth, 2017 burglary and theft by taking, 2 probation violations, 1 FTA.
All right, go ahead.
Your Honor, my client is from the metro area, Your Honor. His mother lives out in Powder Springs, but as indicated in my initial introduction, Your Honor, he is actually going to go to the Baylor House. Baylor House is an inpatient recovery house. It specializes with people who have an addiction to meth, Your Honor. My client has admittedly and is seeking that recovery, Your Honor. While he's been in custody in the 409 days, Your Honor, he was admitted to other programs. However, due to other charges, was not able to have his bond significantly reduced. However, Baylor House has indicated through my social worker, Ms. Raven Ross, through the bailout project would be able to get him, so long as he's able to go through the bailout project, which is going to do the bailouts within, I believe is in the next week or on the 19th to be the exact date, Your Honor. Just to give a little bit more information as to the Baylor Recovery House, it is more than a year-long program. All of it is inpatient, so he will be abided. It's kind of like a better way. He will have to stay on campus. He will also have to go to daily recovery meetings, as well as he will have to engage in random drug and alcohol screenings. They have a very zero tolerance policy, as well as he has to meet with his addiction specialist, as well as stay in compliance with all court rules and regulations. Ultimately, Your Honor, I'm asking for his bond to be cut as such. On the financial identity front, I'm asking for a UJR on financial identity fraud count 2, a UJR through the jail. I'm asking for count 3 to be a UJR. On count 4, I'm asking for a UJR. On the possession of the tools for a commission of a crime, I'm asking for a UJR. On the possession of the firearm, I'm asking for a $5,000 bond. I'm on the possession during a commission of a felony. Your Honor, I'm asking for another $5,000 bond. On count 8, the stolen mail, I'm asking for a UJR. On count 10, I am asking for a UJR, Your Honor. On count 11, I'm asking for a UJR. On count 12, I'm asking for a UJR. On count 14, I'm asking for a UJR. On count 19, I'm asking for a UJR that is also a misdemeanor, Your Honor, and essentially I'm asking for UJRs on the rest. Ultimately, it will be cut his bond significantly where he will be able to be bond out, and then I will be asking that the UJR says to the Baylor program only, so that he will be transported from the jail to the Baylor program.
All right, go ahead.
Also, Your Honor, if you need to hear from Ms. Raven Ross, she has made herself available for if you need more information or about his she was the one who was able to meet with him and be able to conduct his assessment, Your Honor.
Go ahead, Mr. Marquez.
Thank you, Judge. Judge, the state is going to be opposed to any reduction in bond at this time.
A UJR stands for unsecured judicial release. I believe that would also be considered a personal recognizance bond, but it's handled through the jail. So I believe UJR stands for unsecured judicial release.
We believe that he has been issued a bond. That bond was actually addressed on May the 9th of 2023. And I believe that the only count that was not addressed was count 27. So at this point in time, because of the propensity to reoffend by Mr. Wells and the fact that he is a danger to the community at large, we are going to oppose any reduction in bond.
Ms. Ross, is there anything you want to say?
Ms. Raven? Give me 1 second. She says she's trying to take hers off from you.
Okay. Can you all hear me?
Yes, if you could turn your camera on, please, and raise your right hand.
Having a little bit of technical difficulties right now.
Welcome to the club, lady.
Sorry about that, yeah.
Sorry.
If you're on your iPhone or cell phone, just touch the screen and it will give you the option to turn on your video. If you're on a laptop, it will do the same, but using your mouse.
It's telling me I cannot do it because the host has disabled it.
It's telling you the host disabled your, okay, there it is.
Okay. Hello, right?
Raise your right hand, Ms. Ross. Do you swear firm testimony you're about to give is the truth, whole truth, nothing but the truth?
Yes, I do.
All right, go ahead.
My name is Raven with the Fulton County Public Defender's Office. I met with Mr. Wells, I believe, on May 22nd, at which time he did disclose to me that he does have an addiction to methamphetamines. We both agreed that VALAR would be a better program for him to attend. He's already participating in the New Beginnings program at the jail. So with the VALAR program, as previously stated, he will have rules and regulations that he will have to follow. One that is very interesting and I find more holds him more accountable is he will be required to have Life 360, which is a tracker placed on his phone. So if he wanders anywhere or is someplace where he is not supposed to be, VALAR would be notified immediately. Again, he will be have a random and weekly drug screen. They have a zero tolerance policy, which means that if he tests positive the first time, they will send him to detox. If they see that it is a pattern, he will be dismissed from the program. He is required to, again, participate in those daily recovery meetings, and those can consist of counseling, 12-step, or a combination of both. He is also required, to obtain and maintain full-time employment. If that employment exceeds the curfew of 10 p.m., he needs to let the staff know at VALAR again, so they are fully aware again of what he is doing. And also with that back, they will have a tracker.
You heard me?
I'm sorry. Also, they have weekly community meetings, and these community meetings, again, is with the House. They will meet at 6 p.m. all the time, doing weekly check-ins, see what's going on with him. Again, this is a 9-month to a year program with transitional options to help him get back into the community and maintain stability.
Judge, you're on mute.
Sorry, I flipped the form over there and it muted me. Do you have any questions for Ms. Ross?
Me, Judge?
Right. Do you have any questions for her?
I do. Ms. Ross, is any part of that treatment under lock-in?
Yes. So again, he has that curfew. So he is not allowed to leave the facility or come in after 10 p.m.
Okay. Is the facility Thor approved?
Say again?
Is
No.
the facility Thor approved?
No, it is not.
And is he, so the only tracking device that you would have is just the cell phone?
It will be the cell phone that he is going to be required to have on his phone and always enabled, so they are able to keep track of him.
Okay, so is it an inpatient program? I'm a little confused, or is it like inpatient / outpatient where they go work?
No, it's inpatient, but he is going to be required to work. So he needs to be able to fully work. That the only reason why he would leave out of a program is obviously to go to work. But to get like food and stuff like that, that will be coordinated with the team at VALAR.
Okay, no other questions, Judge, from me.
All right. Anything else? I mean, what's your opinion, if anything, now?
Judge, I would still, if we are going to do a reduction in bond, the state would ask for a $20,000 good bond. The problem I'm having, Judge, is the possession of a firearm by a convicted felon, and I'm not hearing, at least in the program, that they're on lockdown, inpatient, they're treated, etc.
Right.
They're just kind of, oh, well, we'll let you go out and you have this cell phone, so they leave the cell phone in a place where they're supposed to go and go do whatever they want.
Was the ankle monitor precluded, Ms. Ross?
No. So if there's an ankle monitor involved, he would be required to have that ankle monitor. They would still accept him. Again, there's no program that is going to force someone to stay there that is unethical and that is against the law. Also, he he would be going out to work. So it's not like they're not going to know where he is. There's a sign out and a sign in. But again, I want to reiterate, there is no residential program that is going to be a 24-hour lockdown program. That is unethical. And you cannot force any client to stay there. That is against the law as well. This is something that Mr. Wells has presented to me, and he is very adamant about doing.
So would part of it be that if he gets kicked out of it because of doing whatever, that could be a violation of his bond condition?
Yes, it is required that he follows, again, all conditions of probation, parole,
Britney
and
Spears?
pretrial.
The 1988 movie, Crossroads. Sorry, I was born in 1988. I do not remember those movies. I thought you meant the Britney Spears movie, which wouldn't have been 1998 either. Probably like 2008. Anyways, also, guys, I have a very interesting article we're going to read after this. Before we end for the evening. I think it'll be very interesting. It's something I've known about for a little while, and I think you guys will find interesting.
And is it spelled B-A-Y-L-O-R?
It's V as in Victor, L-O-R.
B-A-O, Valor, like Medal of Valor. Okay, gotcha. All right, Mr. Marquez. I mean, sounds okay. Thank you.
I'm going to leave it to the court's discretion, Judge.
I've been there before. No drugs unless prescribed. No alcohol. No weapons. You can have.
Yeah, you do. It's always at the court's discretion. Again, it makes you sound so impotent when you say something like that. Just literally impotent.
Ankle monitor paid for by the county. With that 24-hour curfew, anything that the Valor, V-A-L-O-R recovery house requires. So if that's any sort of meetings, treatment, as long as you're participating in that. But sir, that means you will constantly have to let the ankle monitoring company know where you're going. So 24-hour curfew, court, lawyer, medical, participation in the program, and employment. As long as you supply the name of your employer, proof of employment schedule, exact location you'll be working, and also completion and participation and following all of the rules in the Valor Recovery House. If you're late and don't get back in, that's a violation. They'll revoke your bond. Are we clear? Thumbs up. He gave me a good thumbs up. No drugs unless prescribed, no alcohol, no weapons. Let's see. Make sure you got all this. All right. No further contact and follow all treatment plans. Stay away from altruist banks. And before it said you must reside. So once you get out of that program, Mr. Morrell, is he going to reside at the 2855 Overlake Run?
Yes, Your Honor.
All right. So as you complete that program, you must reside at 2855 Overlake Run in Sandy Springs. Let's see. No further contact with, and Ms. Hunter, these are all on my previous bond order. Giselle, J-E-Z-E-L-L-E Jones, Stephen Kwan, K-W-O-N, Tyler Williamson, Richard Bent, Kevin Riviera, Sabrina Christmas, Isis, I-S-I-S Thornton, Carly, K-A-R-L-E-Y Smith, Joseph Vanderbeck, V-A-N-D-E-R-B-E-C-K, Jason Jones, Dontarius, D-O-N-T-A-R-R-I-O-U-S, Summers, Musa, M-U-S-A, A-L-F-A-F-I, Jordan Rock. I think there was another Stephen Kwan Jr. also. All right, so 1,000, 1,000, 1,000, 1,000, 1,000, 4,000, 4,000, 1,000, 5,000, 1,000, 1,000, 1,000, 1,000. And then the last one's when we left off last time, 1,000. You need me to repeat that, Ms. Hunter?
No, I haven't.
All right, 1,000, 1,000, 1,000, 1,000, 1,000, 4,000, 4,000, 1, 5, 1, 1, 1, 1, 1, 1. Everything else is 1. Best of luck to you, sir. If you fail or you get kicked out of that, so completing that one-year program is one of your bond conditions. Best of luck to you, sir.
Thank you so much, Judge Manning. Thank you.
Anything else?
Nothing further. And thank you, Ms. Ross. Mr. Wells, call me when you get to the booth. I'm by my office phone.
All right, I think that's it. Anything from anybody else? Ms. Robinson, you got it? Ms. Hunter, thank you, Mr. Marquez. Thank you, Mr.
Thanks,
Morrell.
Judge.
Thank you, Ms. Ross.
Good night,
Judge,
I think we're
Wakanda.
good, but if I could ask Miss Tanya Mary Collins and Lieutenant Coughlin to stay on.
Okay, so everybody can leave. Thank you, Ms. Hunter. Ms. Hunter, just text me when you get everything in the queue, okay? Because I'm at the state board meeting in Savannah, so.
Oh, I just had a quick question on the last one that we did. Since
Okay.
you're going to the program and you put bond amounts, am I doing like the UJR?
No, it's not a UJR, but that's part of his bond condition is getting into those programs.
Oh, okay, okay, just, okay, thank you.
Right, okay. Unless they work out something different.
Okay. So score, I think it's score. But what I'm going to show you now is just a little something. So I think we would all agree. First of all, let me say hello here. I think that we would all agree that, well, and tell me if you think I'm wrong. The drug that we see the most often people relapsing and having difficulty with, I believe, is methamphetamine. Hands down. Pot, yeah, but that's not the same thing. So personally, I think it's methamphetamine. It is one of the hardest drugs to get off of, if not the hardest. And you may not know this yet, but I personally believe that drugs should be legalized and produced and distributed and sold by the government to people for recreational use so that the people that want to go have a good time on the weekend can do it safely, and they pay a very high price. They'll pay high taxes for that. And the policing services that were originally going after these drug dealers can be redistributed to other crimes. And the money that is brought in by taxes could be reinvested into rehabilitation and addiction programs for people that really need it, not just recreational drug users that want to be safe and use drugs once in a while. So, however, that doesn't actually help what I'm talking about. What I'm talking about now is the difficulty that people have getting off of meth. What I read about recently was a type of rehabilitation and drug treatment called contingency planning or contingency treatment. So it is, again, hard for people to understand and be willing to get behind because they look at it like rewarding people in a way, but it's not like that. So I'm going to read you this article that is from NPR, and it has different, there are different ways of that this program works. Oh, Gracie, you might be right about alcohol, but alcohol is legalized. So I'm talking about illegal drugs. Anyway, so what this program says was the guy goes 3 times a week. He pees in a cup. And if he tests negative for meth, he got paid about $7. They have absolutely proven that even though it is a nominal amount of money, this works in keeping people clean. Okay. A similar program being used in Philadelphia. He would come to the clinic twice a week, provide a urine sample, and if it was free of drugs, he would draw a slip of paper out of a fishbowl. Half contained encouraging messages, typically good job, but the other half were vouchers for prizes worth between $1 and $100. He says, I've been to lots of rehabs and there were no incentives except for the idea of being clean after you finished. Some of us need something to motivate us, even if it's a small thing, to live a better life. The treatment is called contingency management because the rewards are contingent on staying abstinent. And a number of clinical trials have found it highly effective in getting people who are addicted to stimulants like cocaine and methamphetamine to stay in treatment and to stop using the drugs. But they don't want to do it. One of the biggest obstacles to contingency management is a moral objection to the idea of rewarding someone for staying off drugs. That is one reason publicly funded programs like Medicaid, which provide health coverages for the poor, do not cover the treatment. Again, bend over and pick up those pennies while $100 bills fly over your head. Seriously, get over your moral high ground and just fucking deal with it. Like, this to me is so obvious. Again, there are medications that they're using to treat opioid addiction, but really there are no medicines that are proven to suppress the intense cravings that come with meth. Instead, there are a raft of behavioral interventions, some of which have very little evidence of effectiveness. The most common treatment is to do whatever the hell you feel like, basically. And why aren't we doing this contingency management? Why would we spend all this money on interventions that won't work? The fact that no public or private insurer will pay for this contingency management program except in a few pilot programs is a major challenge to expanding it. And the biggest obstacle is that offering motivational rewards to patients has been interpreted as violating the federal anti-kickback statute. A group of treatment experts recently asked the Department of Health and Human Services to waive that statute for 2 years as it pertains to contingency management, but the agency refused, saying programs that provide rewards need to be evaluated on a case-by-case basis. It's silly, yet again. Spend all that money keeping people in jail, and we see the relapse rates of methamphetamine. People that want their kids back and they can't. People that, like, I'm serious. I don't really care what works or how the average person feels about it if it works. I really don't. Now, I'm Canadian. We also don't have this program available in Canada, even under our socialized healthcare plan, as you guys would call it, probably. Again, to the detriment of the people in our world. Not only the people that are suffering from addiction, but the people that work with them, the people that are actually needing to be incarcerated, but the jails are too full of drug users. Like, there are so many reasons why it makes sense to not only look at new and interesting ways of dealing with this, but if you found one that works, like, let's do it. I don't get it. It shocks me. These judges, imagine the cost of drug court even. Imagine just the cost of drug court. All the lawyers that have to come, all the judge that has to be there, the administrative staff that has to put it together. The cost of one session of drug court is going to be more than the payout for that program to the person. Again, bending over, picking up pennies, $100 bills flying overhead. Again, when we decide that we want to punish those as opposed to solve the problem, we will never solve the problem. We will only result in punishing ourselves and everybody else. I get it. Like, when people do bad things, you want them to pay for it. But do you want them to pay for it, or do you want them to not ever do it again? Do you want them to actually change their life? Because the system that we have isn't working. It's obviously not working. This problem wouldn't be the same if all the drugs were legalized and provided by the government in a safe way that people could pay for. But until that point, we are at treating people for these issues. And it baffles me that $7 twice a week can keep somebody clean from meth, and we're not willing to try it. Like, what's the harm in that? Just imagine, what if it worked for fucking 5%? Well, that's great. That's a very cheap program. I mean, methamphetamine is a stimulant. It is not exactly like cocaine. It works differently. You'll find you don't hear as many people addicted to cocaine and not able to get off of it. If you think about it, like, think of the CPS cases that you hear. It's meth and weed, but it's meth, in my opinion, physically changes your brain and changes you when you use it. And so it is very, very, very difficult to get off of, because you are actually different. That's not the same with every drug, and it's not that not every drug can affect your brain, but you can see the decline of meth users very quickly. Adderall is a stimulant as well, that changes into amphetamine in your blood system. Methamphetamine shows as methamphetamine in your system as opposed to amphetamine. So they are different. You guys know I have ADHD, and people that take stimulant medications when they have ADHD react very differently than those that don't have ADHD. And so it is on its own a whole different ballgame. But I think that it just bothers me that they're willing to put so much money and effort into prosecuting people, but not willing to try other things, The other program that they have in Vancouver is something called the Crosstown Clinic, I believe. That is for opiate addiction. Instead of providing opiate replacements like methadone, they actually provide good quality opiates, and the person can go and use as much as they want on site, I think like 3 times a day. But what they found is those people almost immediately stopped stealing. They became stable in housing. They were able to find and maintain employment when they weren't constantly worried about where they were going to get their next fix of drugs. And the cost to the system, yet again, went down. Again, this is something where people go, well, why would you give people drugs? Well, I personally believe some people need drugs to live their life. They've gone through lots of things. And be careful, Charles. But I just think that people need to open their minds a little bit. And didn't die from an OD. Exactly. When you talk about the toxic drug supply, you have to remember that that word is integral there. Toxic drug supply. If you were using fentanyl that you got at a hospital, people don't die from that. They don't overdose on fentanyl that is from a hospital or from the doctor. You die on fake fentanyl that's toxic because it was created in China and brought in and not actually mixed properly. People don't die from good quality fentanyl. That's just not that doesn't happen. It doesn't. You can dose yourself properly. You know how much is in a pill or in whatever you're taking, and you can meter it. That is not the case when you buy it on the street. And that is why people overdose and die. Yet again. So, and that's why redirected medication from hospitals or people's prescriptions are so valuable, because it's actually quite a bit safer for people to utilize those drugs as opposed to getting them in the hospital or getting them on the street. Sorry. Hi, CRD. We've had quite a long evening. We're coming up on 3 hours, if you can believe it. The beans are done though, guys. Let me show you. Made the beans. They're done. Looking pretty good. And I also made rice. So I'm going to have rice and beans for dinner. Anyways, guys, listen. You know me, I could go on for about 1,000,000 hours on 1,000,000 different things, but I have a few plans. Yeah, I know. It is difficult. I've personally given naloxone to somebody. I've personally called an ambulance when somebody was ODing. I have seen that happen. My city that I live in has an exceptionally high rate of homelessness because we have some of the best weather in Canada. And oftentimes what happens is people, they take the ferry to get to our island, which costs money, and then they just can't get off. It's just not going to happen. So anyways, I enjoyed hanging out with you. Where's the Polish sausage? Is that what's supposed to go in the beans? Anyways, guys, I really hope that you had a wonderful evening tonight. I certainly did. I will work on getting the game and changing it and making it even more fun as we go on. And I am going to be putting out some videos tonight as well. Hi, Basement Gardener. So I'm not going live, but I will be putting out videos tonight. So don't worry, you didn't miss anything. It's just me actually working. That is the way I see it. Working hard as usual. Good friend. Make sure you go and like and watch his videos. Great stuff going on there. Seriously, I love you guys so much. We're coming close to 2K, and that's super exciting to me. I love you all. I'm proud of you all, and I'm so thankful that you're all here. So have a great night. I'll talk to you later, and peace out. Peace out. Love ya. Bye.